Go right ahead, Michael.
Thank you very much, President of the Rhode Island Association of Realtors for Reference. The Rhode Island Association supports policies that promote stable housing and fair treatment of tenants. However, H7559 raises serious concerns about property rights, housing supply, and practical operation of Rhode Island's rental market. We'll start with the rental registry. The bill limits the rental registry to properties built before 1978. 1978 is significant because the federal government has banned lead-based paint the prior year. Post-1978 properties are already exempt from lead disclosure laws. This change aligns the registry with existing federal and state law. It eliminates unnecessary inclusion of newer lead-safe properties and reduces confusion for tenants and property owners. I did ask the question with the Attorney General last year. Did you mirror what Maryland did with the rental registry? He replied yes. However, Maryland does not have properties in the registry from 1978 and on. The second one is the unintended consequences of current language. Regarding financial instability for property owners, rent withholding can prevent landlords from paying mortgages, maintaining properties, and addressing safety issues, including lead mitigation. And this can ultimately harm tenants by delaying repairs and upkeep. There's a risk of abuse as well. Tenants may withhold rent regardless of actual property conditions, and a property may be simply awaiting an inspection. Yet landlords could still face penalties and enforcement limitations. There's also a low likelihood of rent recovery if the rent is withheld. And rents are really rarely recovered by landlords when they are withheld, even when there's eviction. This could also mean fewer resources for maintenance and improvements as well, resulting in deteriorating of housing and quality over time. The next section, I'm going to go really fast because I thought I had 3 minutes. The next section is protecting personal safety. This one here, I think, is really important. Did we reach 2? I'm up? Okay. So this is with regards to the registry being public-facing. We really support this bill in taking certain bits of information and removing it from the public. Obviously, I think the state will still have access and departments will still have access to that information, and we don't want this registry to be abused by having cross information pulled for other purposes down the line. Thank you.
Thank you, Michael. Paul?
Hi, my name is Paul Harrison. I am both a real estate agent and a landlord here in Rhode Island. I work directly with renters, property owners every day, so I see firsthand how important it is to balance housing access with community safety. This is Bill H7034 that I'm speaking about. I want to be clear, I strongly support helping people re-enter society and find stable housing. That's something we all will benefit from. But I do have concerns with H7034 as it is currently written. As a housing provider, I have responsibility to the people already living in my properties, as well as the surrounding community. Screening isn't about excluding people unfairly. It's about making informed, reasonable decisions. If we're no longer allowed to consider prior incarceration at all, we lose an important tool to evaluate serious or recent risks. At the same time, we're still held legally responsible for what happens on our properties. That puts landlords in a difficult position. Being asked to ensure safety while being limited in the information we can use to do that. I'm also concerned this will create confusion around what screening practices are allowed, especially for smaller landlords who don't have legal teams to guide them. I believe we both can support reentry, maintain safe housing, but we need to balance an approach that gives clear guidance and allows for reasonable case-by-case consideration. Also, I've been thinking long and hard on this. I have a tenant, young woman with a young child, and I want to know, I treat my tenants as family. I only have 14 doors. I treat them as family, which I really do. And I'll be damned if I'm not going to do a background check on someone. That's what I will. I need to know who is renting my apartments, and I think this is just overboard. With that, thank you.
Thank you. And Trevor?
All right, thank you. I'm going to try to talk, if I can, on the just cause and the rent stabilization, which ironically is also in the just cause. Just cause, I want to go back to actually Representative Place's comments. Students are technically considered month-to-month because they're not in a 12-year lease. And so providing a month-to-month tenancy, one, you can screen your tenant better, but also you can provide more flexibility for someone who is in the area as well. Within that bill, and I'll go over to the separate bill of the rent stabilization, I think one of the biggest things we need to really think about is, we talked about data and how data might, we only trust data when it kind of suits them. But the Public Policy Institute of California, a very renowned source, has said that San Francisco has increased homelessness by 9.8% from 2023 to 2024. In 2022, 67% of the California's homeless population was unsheltered. By comparison, let me go over to the next one, actually. Evictions, if you actually take a look at the numbers, evictions that are recorded right now are 296 that have been filed in the Providence area, which is actually down 31%, and that number is consistent with the year-to-date as well. If you like to contrast that with St. Paul, Minnesota's filing, theirs is up 13% as of recently, with a year-to-date number is very well, it's actually not similar. It's 25% above in 2023 and 2024. Many companies are leaving, and I don't know where people would get their data from, but I know in California, nearly 200 companies, major employers, in fact, have left and taken their jobs elsewhere. I'll just leave it there.
Thank you. All three of you, thank you. Any questions? Seeing none, we'll call the next three. Let's see. Mark Gray. Come on up. Elijah Meline. Is Elijah here? Elijah? Jocelyn Antonio. Jocelyn here? How about Hector Perez? Is Hector here? Come on up, Hector. And Stephen Brown, is he here? He was here. And Kate McGargle from the Rhode Island Center for Justice. Come on up, Kate. Or Kat, I'm sorry. Anyway, why don't you... Definitely, I'll hang on to them. Okay, Mark, why don't you start?
Sure. Thank you, Madam Chair and members of the committee. My name is Mark Gray. I'm the Chief of Staff to Lieutenant Governor Sabina Matos, who requested that this bill be introduced. I want to shout out to Rep. Geraldo for putting it in for us, even though he's not here, but we appreciate that. This is actually a bill, some of you might be familiar with the bill that the Lieutenant Governor has asked to be introduced for the last 3 or 4 years now. This is, I think, the 4th year. The legislation that we're talking about today would ensure that basically that a temporary financial setback that somebody experienced wouldn't prevent them from getting housing. So it makes it so that a credit history or a credit report that a landlord looks at to determine somebody's eligibility for housing only goes back 3 years. The idea being that this is about fairness, it's about economic mobility, so that something like a past job loss or medical debt doesn't make it so that it's impossible for you to get housing forever and ever. And there's a transparency piece to it too, where it requires the landlord to provide written notice with the specific reason for denial based on credit. So that gives the prospective tenant a way to sort of see what the barriers that they really are facing are, and how can they maybe correct errors that might exist on their report or understand how to improve their standing. That's the gist of it. In the past, this was also, in the same bill, restrictions on how far back you could look at somebody's criminal record when it came to nonviolent offenses. So what's different this year is that now that criminal piece is a separate bill that I think Rep. Cruz is going to put in for us. Don't quote me on that. And now Rep. Geraldo has the credit score piece. So because the two things are, they both speak to this idea of like something in your past shouldn't make it impossible for you to get housing for your whole life, but credit score and criminal record are very, very different things. So we found that those were getting conflated. So we asked the two separate bills be put in. But that's the sort of gist of what the bill does. And I think from, as I said, the Lieutenant Governor's perspective, and she's sorry she couldn't be here, of course, herself tonight. She sends her regrets, but from her perspective, this is really about fairness, about making it so that people can get a second chance, can get a fair chance when it comes to housing, just because maybe they had an issue with their credit in the past. So thank you.
Thank you, Mark. Hector?
Thank you, Chair, members of the committee. My name is Hector Perez-Ponte. I'm the Racial Justice Policy Analyst, and I'm speaking on behalf of the Economic Progress Institute. We are in strong support of Representative Potter's House Bill 8108, House Bill 7764, House Bill 8109, and Rep. Cruz's House Bill 7765. Rep. Cruz's House Bill 8109 and House Bill 7765 from Rep. Stewart. Rent in Rhode Island is rising far faster than wages. In 2023, Providence saw the highest rent increase in the country at 7.5%. By March 2026, the average rent statewide was over $2,000, which is about a 10% above the national average. Meanwhile, wages generally increase by just 1% to 2% annually. People's affordability struggles are getting worse, not better. Because of federal actions, 53,000 Rhode Islanders will lose health insurance, 14 will lose food assistance, and health insurance premiums are expected to double for 40,000 Rhode Islanders. To add fuel to this fire, gas prices have risen because of the war with Iran. We support Representative Potter's House Bill 8108 because it gives families predictable ways of managing housing costs. Property taxes increase in Rhode Island are capped at 4% annually by law. Why should homeowners be entitled to more protections than their renting counterparts, especially when housing instability affects every facet of our lives? We support Rep. Cruz's House Bill 8109 because it will help prevent homelessness. A study reviewing the impacts of just cause ordinances across Californian cities indicated that such policies can significantly reduce both evictions and eviction filings, underscoring the efficacy of such renter protections. We also support Rep. Stewart's House Bill 7765 because it will give renters, especially the older residents, time to plan and make informed decisions. Given the volatility of the current housing market in Rhode Island, it's important to give renters enough time to secure stable housing. Lastly, we support Representative Potter's House Bill 7764, which prohibits landlords from using an algorithmic pricing to set rents, ensuring fairness in how rents are determined. All these bills work together to make renting more affordable, secure, and predictable while promoting fairness and community stability. We strongly urge the committee to pass all four bills.
Thank you very much, Hector. Kat?
Thank you, Madam Chair, and thank you, members of the committee. My name is Kat McCorkle. I'm an attorney with the Rhode Island Center for Justice, and I'm here to express our support on Bill 7766 and Bill 8111, the two sealing bills before this committee tonight. Right now, Section 34-1860 of the Landlord-Tenant Act does provide an important mechanism for tenants to seal certain qualifying cases from their publicly available court records. However, this is, as we've discussed, limited to one sealing every 5 years. And in our work, we frequently have to advise and represent tenants who have had evictions filed against them that may be eligible to be sealed, but for the fact that they've had another eviction sealed within the last 5 years. And we not infrequently also have to advise tenants that once an eviction is filed, it remains on their records indefinitely, even if they win, and even if that eviction should never have been filed in the first place. We've heard a little bit about the negative consequences of evictions on people's ability to find housing going forward. I won't repeat that, but it is very important for this committee to note. And I did want to just take a moment to clarify Representative Place's question on Representative Cruz's bill, the difference between her bill and Representative Morales's bill. Representative Cruz's bill 7766 does eliminate the 5-year restriction for all evictions that are eligible to be sealed without changing the eligibility requirements. Representative Morales's bill 8111 gives tenants the right to have evictions sealed that have been dismissed for lack of jurisdiction or defective notice, or if the tenant is a minor without counting those sealings towards their once every 5-year limit. However, under Representative Morales's bill, if passed, other cases that could be eligible to be sealed For instance, if a tenant works out a payment plan and satisfies their arrearage with their landlord and then, gets evicted again, those are still limited to the once every 5-year period. To conclude, we urge the committee to pass both of these bills and to ensure housing stability for our friends and neighbors. Thank you.
Thank you, Kat. Any questions of these witnesses? Seeing none, thank you for coming forward. Is Jocelyn Antonio here? Come on up, Jocelyn. I don't see Steve Brown. How about Nako? Where is she? Oh, here she is. Come on up. And Sam Kramer. Is Sam in here? Come on up, Sam. Okay, Jocelyn, why don't you start?
Good afternoon, members of the House Judiciary Committee. My name is Jocelyn Antonio. I'm a resident of Cumberland, and I'm providing this testimony in my personal capacity as a public health professional. I'm urging your strong support for H 8109. As at its core, public health is about prevention, preventing harm before it happens rather than responding after a crisis. Housing stability is one of the most important ways we do that. When families have stable housing, they experience better physical health, better mental health, and stronger outcomes for children. When the stability is disrupted, the consequences can be immediate and long-lasting. This issue is deeply personal to me. My family was evicted from our apartment of 16 years over a decade ago, simply because my mom refused to sell our family dog to a new property manager. Despite my parents' history of being responsible tenants who always paid their rent on time, that didn't make a difference. My parents were also not informed of their rights and just took the eviction as set in stone. We didn't just lose our home. My siblings and I lost the only place we had ever known. I was home for winter break after my first semester of college, already navigating the challenges of being far away from home and adjusting to a rigorous academic environment. Instead of resting, I was helping my family pack up our lives and move what we could into a storage unit before being given a short eviction notice, while some of our childhood belongings and memories were thrown away by the property manager. That experience has had a lasting effect on me and my college journey. The eviction also made it much harder for my parents to find new housing, and our family of 6 was ultimately forced to live in a 1-bedroom apartment. That experience illustrates what we know in public health. Eviction is not just a legal process, it is a preventable crisis that disrupts families and creates lasting harm. H 8109 is a prevention policy. By requiring just cause for eviction, it reduces the likelihood of sudden arbitrary displacement. Thank you for your time and consideration.
Thank you. Nako, am I saying your name right?
It's Naoko.
Nako.
That's
okay.
close enough. Thank you, Madam Chairman and members of the committee. I'm a member of Reclaim Rhode Island and a history professor. Yesterday, I submitted written testimonies that would be too long to read here, so I'm just going to try to summarize what I'm trying to say and also get to the spirit of what I was trying to say. So in sum, I strongly support all the bills that advance housing justice. These are commonsensical measures that prevent needless cruelty to our fellow Rhode Islanders. This is why I also oppose House Bills 8112, 8066, 7560, 7759. These are the bills that would cruelly add burdens on tenants or impair their right to safety. Housing justice isn't simply about humanity and decency. Housing justice is about creating an upward spiral of well-being in our communities. Tenants with more money in their pockets will spend those dollars in our local economy. School children whose family do not have to constantly fear eviction will grow up to be healthier. They could focus better in school. Stable communities we know are safer, right? People who know each other, we look out for each other. I'm a homeowner, but my 27-year-old daughter doubts that she will ever become a homeowner. It's getting harder and harder for all our children, but it does not have to be this way. There's nothing inevitable or natural about the housing crisis. Rhode Island legislators have the opportunities, and I would say the responsibility, to begin dealing with this crisis in a systemic way that gives immediate relief. Our state government should act in the interest of the many over the few. We need to be also very aware of the disingenuous tactics that present the interests of the few as if they are in the interest of the many. So I urge you all, please, to think about housing justice in an extensive way about how to think about our community here in Rhode Island. Thank you.
Thank you. Sam?
Yes, thank you, Madam Chair, and members of the committee. Happy to be here tonight. My name is Sam Kramer. I'm an attorney at the Rhode Island Center for Justice, where I practiced landlord-tenant law for 5 years now, almost 6. I know landlord-tenant law inside and out. I think I know it better than my own daughter. She's not watching, I hope. But I want to talk briefly about 2 bills. First, 7765, changing the termination of tenancy notice period to 60 and 120 days. I want to address some of the questions that came up. First, Madam Chair, you expressed concerns that that bill would affect non-payment evictions. I can assure you it does not. It is only notice for evictions that are for reasons other than non-payment of rent, specifically no-fault evictions. So non-payment evictions wouldn't be affected. They would still proceed at the normal accelerated pace that's provided for
The
landlords.
30-day notice? All the notices would remain the same for
No,
something
in a
like that?
non-payment, it's actually a 5-day notice once the rent's beyond 15 days late. So that process would be completely unaltered by this bill. All right?
Okay.
Yeah, so
Thank you.
it would only change the procedures for no-fault evictions and make the notice period line up with the notice for rent increase. Because again, it's an inflection point. Do I stay or do I go? To Representative Place's concern about whether or not it creates mutual obligations for notice, I think actually as written it would. If that's a concern of the committee, I would suggest that you consider amending it. If you want to have a different set of requirements for tenants than landlords, by all means, take up that question. Right now, the way it's written, the obligation is equal and mutual between landlords and tenants. The effects are different because landlords have a duty to mitigate if a tenant leaves early, right? Whereas a landlord has a remedy through eviction if a tenant doesn't leave on time, right? But it's worth considering, and it's worth a conversation if that's a concern of this committee. I do want to talk briefly as well about the just cause evictions bill. Very happy to hear Rep. Knight say it's long time to pass this bill. I agree. It does strike a good balance. It does not, I don't think, create anything like an evergreen tenancy, as one concern was brought up. It simply says that instead of sending a notice for no cause, that you have to state the reason. And there are a number of permissible reasons listed in the bill, many of which are driven by basic economics. So there are procedures in place that would allow a tenant to know the reason why they're being evicted, which as an attorney helps me then resolve their situation. Because if I know why they're being evicted, I can reach out to the other side and try to come up with a solution that's responsive to that reason and try to find common ground. Right now, if there's no reason, I'm in the dark and I'm not entitled to that information.
Thank you, Sam. Did you put in written testimony?
I did, yeah, and the Center for
Okay.
Justice put in written testimony on a number of bills. I would suggest, we go into these issues
That's
in greater
great.
depth. Yeah.
Thank you very much. Any questions of these witnesses? Seeing none, thank you. And now Miguel Garcia, come on up. Hugo Vieper, come on up, Hugo. Miguel Woods, Michael Woods, sorry, Michael Woods. Okay. Is he coming? Okay, good. All right, so, Miguel, you want to start?
1 second, my notes appear to have turned off
Unless
on
you
me.
want
I
to start with
apologize
Hugo.
for this.
Yeah. Okay.
Good afternoon, Chairperson and members of the committee. My name is Miguel Garcia, and I am an attorney with the Center for Justice. I'm here in strong support of H. 8141 on the right to counsel. Along with RILS, the Center for Justice regularly provides same-day representation to tenants facing eviction at the Providence and Kent County help desks. And I want to be very clear. The bill does not tip the merits in a tenant's favor. It simply ensures that the rules and processes mandated by court rules, you, the legislature, and the federal government are followed. We are in eviction court every single day. We see crowded courtrooms. We see unrepresented tenants waiting for their names to be called, and eviction cases moving forward against people with no lawyer, very little understanding of the process, and no realistic ability to protect their interests. That should trouble this committee. When shelter and for subsidized properties, public funds are on the line, access to counsel should not depend on whether someone happens to reach our help desk on time. It should not depend on whether legal services has enough capacity for that day. In this situation, landlords usually have lawyers 83% of the time, tenants 4% of the time. So this is the reason why in this kind of system, outcomes are shaped not just by the law, but just by who is equipped to use this process. When tenants appear without counsel, their defenses are missed, defective claims go unanswered, and people can lose their housing without ever having a meaningful opportunity to assert what rights they have. This erodes the rule of law, and it's a structural imbalance, and H 8141 is a direct response to that. It's also fiscally sensible because evictions don't eliminate any costs or make a landlord completely whole. They simply transfer the costs elsewhere, to shelters, to schools, to health systems, and to the public. A system that provides counsel in this type of situation is more just and fiscally responsible. From our perspective, this need is immediate and real. We don't see it in the abstract. So every single day, 50 cases on the help desk, every single theoretical scenario that has been presented here, we've seen it. So for these reasons, we strongly recommend passage of H 8141.
Thank you, Miguel. Can you tell me how many lawyers you have that work in the housing area on the help desk?
We have 10 attorneys at the help desk. 2 of them staff the desk every single day, us in collaboration with Rhode Island Legal Services as well.
So if people have an eviction notice in either Kent County or Providence County, I think that's what you said.
That's correct.
They have the ability to go to the help desk and talk to you.
That's right.
And they should do that on the day they walk into court. I mean, it'd be nice if they
It's
could
not
do it ahead of
ideal.
time, but
We often actually get intake calls, but I would say most of our cases actually do come from the help desk, where within the span of 20 minutes, we need to get to know our client, find any legal deficiencies in their case, and then sometimes go to trial.
okay. Well, thank you. Thank you for letting us know all about that. That's great.
Absolutely.
Okay, and Hugo?
Thank you, Madam Chair, and thank you to the committee. My name is Hugo Vesper. I'm here speaking. Sorry. Is that better? Okay. Thank you, Madam Chair.
There you go.
Thank you, folks. My name is Hugo Vesper. I'm here from Pawtucket. I'm a constituent of Rep. Felix over there, and I'm in a small apartment building, just 6 units, including my own. Just over a month ago, the rent in my building was increased by 44% by our landlord. This was, for most of us, impossible to swallow. Of the 6 households at my address, 4 of them are being forced out after living here for over a decade. One of those units is home to a family with 2 children, one of whom is an infant. I don't know where they'll end up. I know it will be hard. Because their rent spiked by 44%, they're being forced out of their homes where they built their families and settled into their careers. If House Bill 8108 had been passed a decade ago, limiting increases to 4% per year, I believe the shock to their lives would have been avoided. It's a simple fact of our economy that people prefer to make financial decisions in the margins. They are ready and willing to change their budgets according to their needs, so long as they can do so incrementally. We want to grant tenants the chance to make long-term, lasting changes to their lifestyles by limiting those increases to a gradual slope over time, so they can properly adapt to rising costs. When you know it's increasing by 4% year after year, you can plan for it. You can figure out where your budget can be tightened, where it can't. You can work towards a raise. You can seek a promotion. You can get the training or certification needed for an additional part-time job, so you can continue to support your family's needs. You can even safely invest in short-term expenses like a bicycle, a car, a computer, even a business suit in order to achieve that higher income in the long term. And I think this benefits landlords as well, limiting this to 4%, because it's safe to assume that if this bill were to pass, a lot of property owners would make a yearly 3 or 4% rent increase, their standard policy across the board. And it is good for any property owner, I believe, to know that they have a stable, reliable increase over time. It lets them strategize and plan for their expenses, both business expenses and personal expenses, much further in advance when they can rely on that. In this new housing ecosystem where a regular marginal rent increase is common, the exceptions to the 4% would provide an incentive for landlords to perform the important repairs and renovations before the units become unlivable, before tenants complain of emergencies. So I think this bill would say to property owners, raising the rent gradually over time is your right, but if you're going to make cost of living spike overnight, you just need to justify it with meaningful improvements to quality of life. Thank you.
Thank you. Michael?
Thank you, Madam Chair and committee members. My name is Michael Woods. I'm here today on behalf of the New England chapter of Backcountry Hunters and Anglers. I'm only here in support of one of the pieces of legislation that's before you. That's Bill 8110 by Representative Cortvrend. I want to start today by thanking this committee and its members for the tremendous amount of work that's been done over the last half-decade or so to protect, to enhance, to clarify the public's right to the shoreline in Rhode Island. Most of the legislation on this topic has come through this committee. It has been considered here, it's been passed here to the floor, and ultimately it's become law. Of course, back in 2003, we passed a landmark shoreline access bill which clarified where the boundary was between the public's constitutional rights and the rights of a private property owner that lived adjacent. But this piece of legislation is a continuation of a bill that was ultimately passed into law in 2024. What that bill did was impose a requirement for real estate purchases on the shoreline so that both the seller and the buyer were aware of the current shoreline access laws in the state of Rhode Island. What the bill that's before you does tonight is it continues that by imposing a similar disclosure requirement on rental agreements for properties that are on the beach. It is, unfortunately, it happens more often than it should that, for example, somebody renting or selling a property will attempt to sell more than they actually own. They'll sell a private beach. They won't disclose the shoreline right-of-way that the public has a right to use on their property. And what this bill would do, just like we did for shoreline purchases, this bill would ensure that when rental agreements are put together for shoreline access properties, presumably whether they be long-term or short-term, as is common in Washington County where I live, that everybody involved in that transaction would be above board, that the renters would know exactly what they're purchasing when they sign into that agreement, and they wouldn't be disappointed or duped later. So for that reason, we urge you to support this legislation, and I'm happy to answer any questions you might have.
Thank you, Michael. Any questions of these witnesses? Seeing none, thank you all. Next, we have Jonathan DeJesus, Jordan, I don't know, Tomei, does that sound right? Jordan? And Caleb Madison? Okay. Jonathan, why don't you start?
Good evening, honorable members. My name is Jonathan DeJesus. I'm the community policy advocate for Progreso Latino. At Progreso Latino, our mission is to help Rhode Island's Latino and immigrant communities achieve greater self-sufficiency and socioeconomic progress by providing transformational programs that support personal growth and social change. Progreso Latino writes in strong support of House Bill 7765, House Bill 8019, and House Bill 8108. From the direct services we provide regarding housing, many of our constituents have been placed in a position of survival due to how fast rents can increase, forcing them in uncomfortable situations. Our caseworkers constantly direct many of their clients to Rhode Island Legal Services due to eviction notices related to non-payment of rent. The reason why many are evicted is due to high rent increases and such short notice. After an eviction, many people struggle to find a new place quickly. Landlords often screen for past evictions, leading to temporary housing, overcrowded living situations, or homelessness. From the 2024 Housing Fact Book, 74% of Central Falls population rent, and an average two-bedroom apartment is $1,637. A family will need an income of $65,480, and statistics from the 2024 Rhode Island Kids Count Fact Book states that the median family income in Central Falls is $45,159. We have now triggered a chain of reaction in mental and emotional stress, employment disruptions, and long-term barriers. By increasing notice to renters from 30 to 60 days for rent increases and limiting rent increases to no more than 4% annually, we are now placing families in a position in which they can find an alternative safety net or provide a peace of mind knowing rent is at a predictable position. Our tenants can now budget better, save money, invest in education, or achieve their dream goal. Thank you to all lead and co-sponsors for their leadership, and thank you to the honorable members of the House Judiciary Committee for your consideration on this impactful legislation. Thank you.
Thank you. Jordan?
Thank you for the opportunity.
Yeah, turn your light on, please. Thank you.
Thank you for the opportunity to speak. Thank you for hearing us out. My name is Jordan Toll. I'm speaking from Reclaim Rhode Island. I want to express support for the legislation today being considered in favor of further renter protections. In a previous life, my job was to manage about 50 properties across the greater Providence area. And to be candid, the more I worked with landlords, the more I believe that the free market and good intentions are not adequate to solve today's issues in housing. I've seen firsthand many landlords and their neglect with bed bugs, lead paint, countless other code violations that go unenforceable. I mean, the difference between what happens in housing and what ends up on paper and enforced, whether it's fines, whether it's citations. The gap is really astounding. Transparency and enforcement strengthened by this legislation. It's common sense. There are well-meaning mom-and-pop landlords that are out there, and I've worked with them. A lot of them are already in compliance with what's being suggested here. A lot of this is common sense, and I've seen from both sides of this issue, and I would ask folks to support this legislation. Thank you.
Thank you. Caleb?
Good evening, and thank you all for your time. My name is Caleb Madison. I'm the organizing director for Reclaim Rhode Island and the Rhode Island Tenants Union. Part of our work is to go around and hear stories from tenants all day about what they're going through, what their experiences have been like, what's it like being a renter. What I can tell you after hearing so many of these stories is just how outbalanced the scale is in terms of the power that the landlord has over the tenants. Hearing about things like abusive relationships that you stick in so you don't have to deal with trying to find a new place to live, people living with black mold, bed bugs, you name it. People have tolerated it because it's the only thing that they can do. And I feel frustrated tonight as I sit and I hear this narrative over and over again as though the landlords are going to come up and they're going to give you the real facts and data, and what the tenant people can give you is just stuff that tugs at your heartstrings. That is factually not true. Data shows and policy experts show that things like rent stabilization, being able to have the right to counsel, and just cause protect tenants and enhance their ability to have a decent and stable life. One fact that I can tell you is 100% true is this. If we pass nothing, we will continue to see homelessness increase, we will see renters struggle, and we will see no change in the common Rhode Islander's life. Meanwhile, if we pass these sorts of common sense reforms, there is not a single landlord who will become homeless. There's not a single one who is being shackled to be able to lose profits. There's no chance of them ending up on the streets. Why? Because they own a six-figure asset that the renter does not own. Thank you.
Thank you. Thank you, all three of you. Any questions? Seeing none, we're going to go to the next group. Angela Lizzie Ford, Jennifer Wood, Tina Christie Mancini, no. How about Mike Semko? Is Mike Semko in here? Carol Costa? Katie West? Come on up, Katie. Okay. Angela, why don't you start?
Hello, everybody. My name is Lindsay Ford, and I'm supporting the work of Reclaim Rhode Island and Sistafire. I live in Mount Pleasant. I support the bill 8108 because it ensures landlords in Providence are more like mine. I have wonderful landlords who offer me stable rent and are transparent about changes. My landlords consider the impact of their decisions on me, and I faithfully pay the rent payments that support them. This partnership is the heart of what makes Providence a place I can belong. My last apartment was a more common Providence experience. Between 2019 and 2024, my rent increased 4 times. I paid the increases 3%, 4%, 10%, 21%, and I paid consistently, but I never felt stable and safe where I lived. How much money would I need to stay? I had no idea. Why was the rent changing? I had no idea. And as I became more and more connected with my neighborhood, I was more and more afraid of rent lease renewal because everything I've invested in could be gone. I felt like an object to be replaced rather than a person who loves the city and a valued partner in the long-term wealth generation of Providence. Bill 8108 isn't about suppression. It's about respecting the true value of housing. It's a commercial good, but it's also where we celebrate birthdays and parties and holidays. We make the memories that define our lives and keep the people we love most safe, especially our pets. It's a container for the things that are priceless, a quality that the market was never designed to understand. Priceless is the time we spend with people in the places we belong, our home. And if we ever have to leave, it's important for our city that ensures that it's justified and truly worth it. Thank you very much.
Thank you. Lindsay, right? Yes. Okay. Tina?
Good evening, Chair. Chair McEntee and members of the committee, my name is Tina Christie Mancini. I am the Chief Compliance Officer at the Rhode Island Commission for Human Rights. The Commission supports House Bill 8274, and in fact, the Commission has asked the bill to be introduced. Thank you, Representative Agello, for introducing the bill for us. It's intended to make some conforming changes that have come up since the Fair Housing Practices Act was last amended. I wanted to clarify that another version of this bill, House Bill 8105, was introduced but has been withdrawn. This bill contains the language the Commission intended and does not make any changes to the Fair Housing Practices Act with respect to assistive animals. This bill makes 3 changes to the Fair Housing Practices Act. Number 1, previously the General Assembly added housing status, whether a person is housed or unhoused, to the definitions section in the Fair Housing Practices Act, but the housing status is not added to the section prohibiting discrimination. This is causing ambiguity about the Commission's authority. This bill adds housing status into the unlawful housing practices section to make it clear that the Commission has authority over those charges and to clarify what we believe the General Assembly intended when adding housing status as a protected category previously. Number 2, the bill also removes unconstitutional language in the law that bars complainants and respondents from discussing their cases publicly. In the past decade, the Commission was sued over similar language in the Fair Employment Practices Act, and that language has subsequently been removed. However, it remains in the Fair Housing Practices Act. And finally, this bill amends a provision concerning discriminatory advertising. Rhode Island law prohibits discriminatory advertising, but not discriminatory statements or notices. Federal law prohibits all of these, and this bill would make the state conform with the Federal Fair Housing Act in this respect. For these reasons, we ask the committee support this bill and vote to pass.
Thank you. Katie?
Thank you. Good evening, Chairwoman and members of the committee. My name is Katie West. I'm the Director of Strategic Partnerships of the Housing Network of Rhode Island, which includes a network of mission-driven housing providers and property owners, as well as organizations who serve low-income individuals, including folks experiencing homelessness. I am signed up on 12 bills tonight, so you have my written testimony both in support of the 8 as well as our opposition to 4 bills. I do want to acknowledge the efforts of the General Assembly over the past several years around housing. Shout out to Representative Shikarchi, or the Speaker, who is my representative. I think the point I want to drive home this evening is that addressing our housing and homelessness crisis is not something we can build our way out of, especially when we continue to see pushback from cities and towns to new development. The National Low-Income Housing Coalition recently published a report showing we're short about 23,000 units for the lowest income Rhode Islanders. And so in addition to focusing on production and investing in solutions such as a state-funded rental subsidy, which is something we're advocating for this year, we feel it's imperative the state adopt policies that encourage stable tenancies, reduce evictions, and stem the tide of people flowing into the homelessness system. We feel the bills that we're here in support of tonight are propose very reasonable, moderate, and cost-effective solutions to the issue that affects everybody in our state. And if we want to reduce homelessness, they're a part of the path to doing that. I do want to quickly mention on 8109, we feel that this captures common eviction scenarios. We did make a minor suggestion to clarify the exemption for rent-regulated properties, which is in our written testimony. And on 8066 and 8112, we are concerned on 8066 about consequences, unintended consequences and discrimination to our unhoused residents. And on 8112, the burden that would be placed on tenants for having to come up with additional fees to rent units, especially for nonprofits that might be also supporting tenants with those first and security. So thank you for your time tonight.
Thank you. Any questions? Seeing none. Robert Livingston? Elizabeth Hubbard? Bob Marshall? Nathan Jewett? Come on up, Nathan. James Height? Who we got here? James, I think, are you James? I guess I called too many. You'll be next, okay? Sorry. Okay, see if Jennifer Wood is out there. Okay, thank you. All right, Robert? No, who's first? Let's see. Just give me a name. I just called
Nathan.
Nathan. Okay, Nathan. You're up.
Yes, Madam Chairman and members of the committee, thank you for this opportunity to, I'm here to testify on House Bill 7758. Nathan Jewett, I am an associate certified entomologist with over 2 decades in the pest management industry. I'm here representing Big Blue Bug and New England Pest Management Association, which serves professional pest management companies throughout Rhode Island and New England. This bill addresses a serious and often misunderstood public health issue, bedbug infestations. The EPA has classified bedbugs as a pest of significant health importance. Infestations are associated with allergic reactions, secondary skin infections, insomnia, significant anxiety. The toll is both physical and psychological. Importantly, this burden is not evenly distributed. 2020 study conducted in Chicago found that bedbugs disproportionately impact lower income communities, making this not just a pest issue, but an equity issue. And in my field experience, infestations are often worse and spread for three primary reasons. Either the tenant delays reporting out of fear of blame or repercussions, landlord is unclear on responsibility or delays action, untrained individuals attempt to self-treat, often making the situation much worse. Bedbugs are definitely not a do-it-yourself problem. Improper pesticide use driven by the misconception of more is better can lead to unsafe conditions. And you see that all the time. We have unfortunately seen cases across the country where misapplications have resulted in serious injury, even loss of lives. This bill helps correct these patterns. It promotes early reporting, clarifies responsibilities, and requires professional treatment. Just as important, it recognizes that successful eradication requires cooperation. So this shows that tenants, landlords, and pest professionals have a responsibility. So I would encourage you to support the bill. I think it could really help with eradicating bedbug issues before they really get out of hand. And happy to answer any questions after everyone else is done.
That would be nice, right? No more bed bugs. Anyway, Bob Marshall, you're up.
Chair McAtee, members of the House Committee on Judiciary, thank you for the opportunity to come before you on behalf of the Rhode Island Developmental Disabilities Council to speak on Rep. Serper's House Bill 8215, which proposes to amend the Rhode Island Fair Housing Practices Act as it applies to service animals and emotional support animals needed by Rhode Islanders with a disability. As I testified last session, this act, as it currently exists, was put in place to protect citizens that require service animals and emotional support animals from intentional or unintentional discrimination by landlords, and is based on civil rights protections included in the ADA. We have 3 areas of concern regarding the proposed amendments, all of them appearing on page 5 and 6 of the bill. 3437-4E3I defines emotional support animal as only a cat or a dog. This is more restrictive than the ADA, which does not limit the type of animal that can be emotional support animal. Disability Rights Rhode Island has represented several clients that had birds as emotional support animals. This would make that difficult, and fish. I wasn't going to go through all of them. Then on 34-7-4E32, permits the landlord to deny a reasonable accommodation to have an emotional support animal if allowing the animal to be kept on the premises would result in cancellation of the property insurance or a substantial increase in insurance premiums. A reasonable accommodation can only be denied if it would impose an undue burden and be fundamentally alter this housing program. Policy cancellation in itself cannot be a reason to deny accommodation. The landlord would be required to seek other insurance that can accommodate the animal. If the landlord is unable to find another policy, that could be evidence of an undue burden. Additionally, a substantial increase may not constitute an undue burden. The language in this section should reflect the need to prove an undue burden. And then lastly, in 34-7-4E34D, requires documentation for the need for an emotional support animal to come from a healthcare practitioner licensed in Rhode Island with a physical office in Rhode Island who has an established relationship with the patient for 30 days prior to providing documentation. These requirements are more restrictive than the ADA and would adversely affect individuals with disabilities. For example, if someone was moving to Rhode Island from out of state, bringing with them their emotional support animal and appropriate documentation from the treating provider who is licensed elsewhere, they would be expected to give up the emotional support animal while they establish a new relationship with a treating professional in Rhode Island. Such a requirement would be discriminatory and for many people not possible to move at that point. We thank you for your time and be happy to answer any questions, but those are the concerns that we have.
Thank you, Bob. Elizabeth?
Good evening. I am Elizabeth Hubbard from the Governor's Commission on Disabilities, and I share many of the concerns that my colleague Bob Marshall mentioned. I will say, though, that this is a very controversial issue within the disability community, service animal versus emotional support animal. And an important distinction to note is that service animals, when you're considering going out into public places, that's governed by the ADA, and it's actually the Fair Housing Act that governs an accommodation in housing, which is why the Fair Housing Act actually uses assistance animal, which lumps together service animals and emotional support animals into one. And last year, there were two different bills that were looking to create this distinction and give a more substantial definition to emotional support animal. And while I feel like this bill has good intentions in trying to do that and trying to mediate something between the landlords and people with disabilities, it's gone a bit too far. So the first section that talks about, defined service animal, that is good. It copies the ADA. However, when we get into emotional support animal, that becomes problematic. Firstly, there's the issue of having a treatment provider who has a physical office in Rhode Island. A lot of people get their treatment over the border. If you live in a bordering town, sometimes the closest hospital or medical center or doctors are in either Connecticut or in Massachusetts. There's also the issue of the 30 days. If somebody is just getting treatment and they go up to their first appointment for our first few appointments and it hasn't been 30 days yet, that might still be enough time for a treatment provider to say, yes, this person does require an emotional support animal. In addition, restricting it to a cat or dog is also, that's overstepping with the requirements of the Fair Housing Law. There's no requirement for that. And there are people who might, because of allergies or other issues, might prefer to have or need to have a different type of animal than a cat or a dog. As Bob mentioned, there's been at Disability Rights Rhode Island, where I used to work as an attorney there were people represented different types of animals, including one for fish that was emotional support animal. So I think just want to say that, for these reasons, we understand the bill's intentions. That's those sections that go too far and are too restrictive really are too much of a burden. And then with the undue burden issue, the landlords do not, aren't defenseless in light of this. I understand oftentimes they feel so. It's because of misinformation, and I welcome them to contact our office or South Coast Fair Housing, Rhode Island Commission on Human Rights, to know that
I think it's time to wrap it up, though.
Okay. They are not required to permit an animal. Well, I'm the expert in the state on this issue.
I know. Well, here's what I suggest you do, is talk to Chairwoman Serpa. I'm sure she would be happy to work with you to make the bill a better bill, and maybe talk to some of the landlords and see if you can work a compromise. Because some of the things that you're saying seem like they'd be pretty easy fixes.
Yeah,
so, both of you. Yeah.
Thank you.
Thank you. Any questions of these witnesses? Oh, go ahead, Chairman Bennett.
Other than a dog and a cat, what does the ADA consider an emotional support animal?
So the ADA defines service animals as being a dog, or in some cases people have miniature horses that act as service animals, but emotional support animal only applies under fair housing. So that's under fair housing law. So fair housing law does not define, it just says an animal, that is somebody that provides emotional support as a reasonable accommodation. Understandably, there's some sort of reasonableness to the reasonable accommodation, so it would be better if there's a traditional domestic pet, things like goldfish, bunnies.
A small horse might be difficult in some places.
Well,
Sure would.
yeah,
I don't know.
In some areas, if you have a townhouse and, someplace, maybe you could, but,
Okay, you all set? All right, thank you all for your testimony. And James Height, come on up. Steve Stasiak, is he here, Steve? Robert Diaz, okay, is Robert Diaz here? Okay. Shannon, that's you, right? I can't read your writing, Shannon, what's your last name? What? Oh, okay, Shannon Weinstein. How about Greg Weiss? Is he here? Come on up, Greg. Okay, James, you're up.
All right, thanks for being here. All right, so I'm a landlord, have a multifamily that I own or occupy. I'll run down to several things here.
Do you have your light on, the green light? Yep,
Yes.
okay.
Yes,
Right.
it is. I'm familiar with it. Anyway, so Bill 7559, the lead registry. Yeah, I'm for that. A lot of the provisions of that, especially the public information. I was just really appalled to have my look on the registration, see all my stuff out there for the whole world to see. And, the 7560, the lead hazard mitigation. There was a point made about maybe some units not supposed to have rented to tenants in the first place. I'd just like to know why you want to keep somebody in a unit that's not in compliance. I would want them out as just a human to human, and certainly not allow it to be re-rented, but I don't think anybody should have to stay in that, even if it's rent-free. It's like, why do you want to be there? All right, so anyway, the House Bill 7034, the prohibiting of criminal background checks. Well, I rented families with young children. I certainly want to know who was there. Before being a landlord, I rented an apartment in Central Falls and had the level 2 sex offender with a violent temper move in on the second floor. So that would have been something that I don't know if it was required at that time, but certainly I think that landlord should have notified me of that. The House Bill 8108, the 4% limit. I think that'll actually hurt tenants. There's tenants, like I have tenants that rent hasn't increased, but I'll now have to increase it 4% just to keep ahead of all the other expenses. And just one more point, the just cause eviction. I have tenants that want the flexibility of month to month, not be locked into a lease. Many tenants over the years. Thanks.
Thank you. Shannon?
Hi, thank you. My name is Shannon Weinstein. I'm here on behalf of the Rhode Island Coalition of Housing Providers. Personally, I'm a realtor, property manager, landlord, and a contractor. I've been working in this housing sector for just shy of 20 years now. The coalition is opposed to the majority of the several landlord-tenant bills that are introduced for consideration, with the exception of support for the lead and rental registry reform, protection from squatters, and bills 8112 and 8215. Many of these proposals that we oppose have been heard in prior legislative sessions. They repeatedly come back, and repeatedly the same concerns regarding the impact on Rhode Island's housing environment are raised. While well-intentioned, these policies would add further restrictions and regulatory burdens to an already constrained housing system. Increased regulations continue to push our state back towards the same policy environment that contributed to the current housing shortage in the first place. Overregulation discourages investment, reduces housing production, and negatively impacts our most vulnerable populations the most. These regulations negatively impact every single person in our housing market, whether it be the renter or on the homeowner side. In regards to policies like rent control, just cause eviction, and right to counsel, I would urge the legislature to perform a financial review and obtain a fiscal note. These policies fail to achieve intended results while also causing massive destruction to the tax base and creating a redistribution of the tax burden to owner-occupied single-family households. With rent control policy, there has always been exemptions, and regardless of those exemptions, the policy still carries the negative unintended consequences. So any way you mix up this policy, it still has the same impact. We respectfully urge the legislature to once again reject these policies and instead pursue policies that promote a balanced and functional housing ecosystem. Due to the limited time, I can only state short support for the proposed legislation that we have, laws that classify squatters as trespassers rather than someone with tenant rights, laws that target lead safety while avoiding unnecessary cost pass-throughs and limited results, laws that clarify the process for those in need of emotional support animals, and permissive legislation to allow collection of first, last, and security would all help increase or preserve housing, improve landlord-tenant relations, and spur more affordability. We've heard some of the concerns tonight, and we are willing to work with any of those concerns to come to a reasonable agreement on any of those proposed legislation that we support. We are open to all those suggestions, and Rhode Island's housing challenges will not be solved through additional restrictions. We encourage policymakers to focus on measures that expand housing opportunities and support long-term housing stability across our state. In response to some of the points that were raised tonight, I was also a commissioner on the Landlord-Tenant Commission, so we did study the policies like just cause eviction and the eviction ceiling bill that Representative Morales introduced, and there are discrepancies between what was agreed to in the commission regarding that bill specifically and what we see here today. So I'm happy to answer questions on the long list, anything that you have on there. If you have a question, I'm open to communication with anyone. We submitted written testimony. Thank you.
Thank you, Shannon. Greg?
Hi, I'm Greg Weiss. I'm a Rhode Island realtor and a property manager for the last 20 years. I want to echo what Shannon has said about rent control. Many of the issues that we heard about tonight are actually the symptoms of a lack of adequate supply. They're not a lack of regulation. And whether it be from the price of rent or the condition of units, adding more supply is the answer. What we want is landlords to compete over the condition of units, improve outdated units, lower their rent to find tenants. And I want to make it very clear that the Just Cause bill that we've heard about tonight includes a provision for rent control. So if we think rent control is bad, and the consensus is that over time rent control actually decreases the supply of rental units, then we need to consider that when we're talking about the Just Cause bill that's on the agenda tonight. However, I'm actually here to say I support 8215. That's the emotional support animal bill. It's a significant challenge today for landlords to be able to verify a tenant's ESA requests right now. The reason that's a problem is because you can go online, any of us can go online right now and order a ESA certificate, and you'll have it the same day for a small fee, and most often without any proper medical evaluation. So this actually diminishes the credibility of legitimate ESA requests. So what the bill does, and I heard what Bob Marshall and Lauren Hill had to say, and certainly I'm sure there's room to make this bill better, but what it does is it aligns Rhode Island's definition of service animal with ADA, and it makes sure that tenants must establish a relationship with a medical provider that's licensed in Rhode Island, and they have to treat them for at least 30 days before providing that certificate. So this ensures tenants with legitimate ESA needs cannot be unreasonably denied. The second thing I want to touch base on is 8066. That's a squatter bill. It specifically states here a squatter is not a tenant, including tenants that have a holdover periodic tenancy. So I'll just wrap up here. This does not apply to public property. This is solely for private property, and this is solely for bad actors that have entered the property and never had any authorization from the owner.
Thank you. Any questions of these witnesses? Seeing none, oh, go ahead, Representative Knight.
Thank you for pointing out that the rent control piece is built into the just cause thing. If that sees the light of day, my gut would be that that would be excised out, because that's it's a different policy than just the eviction issue.
Right. Thank you.
Thank you. Michael Greco. What's your name? Come on up, Steve. Come on up. Michael Greco, and you have your son, I believe. Come on up. You can come with him. Go ahead. You can sit there. Go right ahead. All right, Steve, why don't you start?
Thank you, Madam Chair and members of the committee. I am a property manager. I represent a property management company that, Stone Lake Property Management. We represent about 1,500 properties throughout Rhode Island, Southeast Massachusetts. We have a lot of insight into the industry. I wanted to show my opposition to Bill H-8109, which is both just cause eviction and rent control. There is data out there. Data is real. We shouldn't be basing our decisions on emotion. We should be basing our decisions on hard data. A lot of the people were talking about housing supply and maybe a sundowner law earlier today. If you want to put a scarlet RC on the city of Providence and the entire state of Rhode Island, introduce rent control. You will not get development in this state. People will stay away from it. It's already cost prohibitive to bring new properties in here. If we're trying to increase property or vacancies in stock in property here, rent control is going to drive that away, in addition to all the other things that are already doing that. The just cause eviction, I just want you guys to also know another couple of real numbers. If you have vacancy, it's going to cost you 25% of your income on that property in a year. It's going to take you 1 month to find a tenant. You're going to have to pay somebody to find that tenant. And if you get lucky, you're only going to have 1 month of costs to return that property to the quality of properties that we all strive for our local communities. If you would throw an eviction onto that, you're talking about 40%, because it's going to add another month to the eviction process. Eviction costs money. People aren't out there evicting. We do want long-term tenants. We do want long-term stable residencies. And then lastly, the interest on security deposits. Let's go with another number. The bankrate.com says the savings account yield brings out a yield of 0.39 to 0.62% annual. Okay? So if we take the average on that and a $1,000 security deposit, in 1 year you're going to get $5. Okay? Additional, well, and this is some data for us, is the average tenancy is about 22 months that we see. Over that time, that's going to yield $9.16. That means that the landlord has to establish a savings account, report on that, and deliver. I'm not saying that rewarding a tenant and somehow making a yield for that tenant be out there, but let's be realistic. You're asking for somebody that is going to pay $10 or receive $10 on a security deposit, that the landlord has to incur that kind of work. I think there's a better solution to that one. Thank you.
Thank you. Michael?
Hello. My name is Michael Greco. I'm a medium-sized landlord right now. Went from a small-sized landlord to medium recently, and I want to sound the alarm on a couple of things here. One of them is that these over-regulation sort of packages make it really hard for people like me to be able to keep up with large corporations. And I think while some of these things are well-intended, people like me who take what was originally an unsafe property and make it safe and care about my tenants and live in the same neighborhood as them, I'm looking at selling and getting out of here, and I'm looking in other states. And one of the reasons I'm doing that is because the fact that we keep having to discuss this year after year has got me afraid. Additionally, when we do take unsafe properties and make them safe, a lot of that money goes into the hands of immigrant workers. And these, I'm married to a Mexican immigrant. I studied cultural anthropology in college. I did work to help immigrants acclimate to the United States. And when you are speaking English as a second language, if your work is good, you can get a good paying job. In the last 3 years, all of the money that I made from rent went back into the hands of workers in this state. And many, many of them were immigrant workers. The percentage for drywall, roofing, and painting, immigrants make up about 50% of that workforce nationally. And so I think there's some unintended consequences for those people who are speaking English as a second language here as well, and I know that the state of Rhode Island values that. So when I look at these situations and I look at the large corporations who can afford, for example, to make more repairs than I could, or can afford, if a mortgage resets because 5-unit buildings have to are variable, or can afford lawyers to understand all these regulations, I think what ends up happening is people like me have to sell and we have to leave. I don't want to see that.
And I'm sure Sebastian doesn't want to either, right?
Thank you.
Thank you. You want to say anything, Sebastian?
So I'd just like to say, if all the mom and pop businesses, like rental, go and leave, the bigger corporations are going to end up taking over, and it's gonna end up just being one big business in Providence and Rhode Island instead of a ton of little mom and pop businesses.
Well, thank you for that. You're very well versed in this, aren't you?
I have one more thing to say.
Oh, go ahead.
I'd like to say that they would also have entire control over the rents that they charge if they were to control most of it. So they could control how much it would be to rent in the state of Providence, and they could raise those rents insanely high, well, very high, because there's no other supplier.
Okay, thank you. Very good.
Chairwoman, I have a couple questions.
Oh, go ahead.
Thank you. Thank you so much for your testimony. I agree with you. Corporations are taking over, big real estate investors. I'm just curious to ask, you said you are a medium size. What's the definition of that? What does that mean to you?
So I can walk to all my properties from my home. I have a 3-unit building. I have a 4-unit building, a 5-unit building, and 2 1-unit buildings.
12, so it's, 14. So you have 14 units?
I do.
Okay, I wanted to, instead of medium, I know like small mom and pop is someone who owns 1 to 4. So I just wanted to get the clarity from my own perspective from what
14 units, yep.
Thank you so much.
And they're all, most of them are affordable housing.
Thank you. Well, thank you for that too, because we need that. So I appreciate you sharing that, and I share the concern about large corporations and investors coming in, taking up a lot of the units and taking away from people for first-time home buyers, and also their kids to have housing. So I appreciate that. I had a question. You mentioned a couple questions.
Sure.
Where do you hold the security deposits now for renters?
In an escrow account.
Okay, in a separate escrow account from you. And what was your company again?
Stonelink Property Management.
Stonelink. Okay, so that's the first news I've heard. I know many Stonelink tenants. I've been in many of your properties. You have properties in Pawtucket.
Yeah, we've got properties throughout the state, actually.
Yes, and I noticed you have several vacant units in Pawtucket that have been vacant for quite a long time.
Sure, absolutely.
Yeah, so why is that?
They're probably priced wrong by the owners that own them and dictate what the prices are that we can market them at.
So is that your job to advise them on?
We absolutely do, yeah. Because our goal is to balance vacancy with rent. And we want, it doesn't, from a business standpoint, it doesn't make good sense to leave a property vacant.
It doesn't. That's why I was concerned when you talked about it doesn't make sense. And I'm like, here it is. There's no sense because they are vacant. And they've been vacant for a long time because the neighbors and tenants who live in those buildings had shared that. And we're concerned that they know with the housing crisis, why these units are vacant.
Sure.
And I guess the other thing, you shared a troubling statistic or, and that, yes, recently, the average length of time has been 22 months. And you know what I attribute that to? Is less protections for tenants to stay in their home. And the rental increase, we had one of the highest in the country. We can't doubt it. No one here can. We've had one of the highest increase, and many people have been pushed out because of it, right? Of that doubling of the rent from 1,000 to 2,000. And why we're seeing this shorter length of stay. So I think that's part of the market as far as tenants, because you described that, and I don't think any landlord, at least what I'm hearing from you, we would want to go back to the 10 years, 15 years, because a lot of tenants do stay in
We would love,
units.
we would, that's a great point. We would
So
love-
how would you
love-
make that happen?
Well, I mean, the way that we try to do this is tenant retention is a very important thing. One of the things that we do, and it's a great strategy for tenant retention across the board.
What is a great strategy?
Is maintenance and addressing concerns of tenants. And answering the calls and being there for that. The 22 months is actually ahead of the average. The average stay in a property is 20 months. And so, and now it's not knocking the ball out of the park, but the goal here is to keep tenants in their place, because one thing that we advocate for to our clients is the tenant is the asset. A property isn't going to be profitable. A property isn't going to deliver without a tenant in there, which is also why we try to guide the clients. And by the way, we represent clients that are mom and pops, 1 and 2 doors, 1 door, single properties, up to larger portfolios in the hundreds. But our goal is to get people into those properties, get responsible people into the properties so that the other people that are in there are safe. We have a vetting process that does that keeps in mind all the discriminatory laws. And ideally, our goal is to not have vacancy. We don't like it.
Not to prolong this, because I know the chair. I'll just respond quickly. And I know you mentioned maintenance. I agree. Unfortunately, that doesn't happen. But rent increases.
Sure.
That has a lot to do with it. We can't deny it. And I'm sure rent increases are what has been happening.
There are certain landlords and there are certain people out there that do this. And
So if you want to keep a tenant in, I'm sure you look at, well, if I raise it 80%, they're gone.
They're going to leave, right? Absolutely.
So why does that keep happening? And you don't have to answer because I want to take this time, but I want to put that on the record. I mean, you said maintenance, I agree.
Sure.
But also, what shortens that time is the rent increase. I was in a unit for 2 years. What happened? Rent increase. I'm like, what? Nothing's changed. It's gotten worse. No repairs. I left.
But you have to let him.
So I just wanted to do
Cruz,
that.
you need to let him answer.
Yeah,
You've asked him several
No,
times.
it was a comment to what he had said, and that was it. So no
But
question.
I would like to address that is because,
Okay, we can keep
unfortunately, the rent increases accommodate things like, in the last 3 years, we've seen a 50% increase in insurance. Okay? We've seen, everybody's seen inflation going up. Gas right now is crazy because of what's going on. And there are a number of costs that are increasing across the board. These are real costs. Now, when our advice, and what's good advice in this industry, is when you do a rent increase, is that you actually stay under market. And the reason why, and we would encourage people to do this, is because we don't want vacancy. We don't want people to move out because it's going to cost the client. I mean, this is business 101. This isn't made up. I mean, these are real costs. People, clients of ours are struggling to make their properties work because of increased costs across the board. Our labor costs have to go up because things are more expensive. So if we could keep our rents all the same, sure, but we don't live in a vacuum like that. We have real costs and real things that we have to address. And if the committee wanted to address insurance, there's plenty of ways that we could go after that. We can go after a number of the utilities.
Okay.
But
we got you.
I would like to
getting off
respond.
topic. Okay,
I would
go
like to
ahead.
respond. Thank you, Madam Chair. Tenants pay gas. I get it. Nobody's asking for rent to be the same. Everybody's different. Every unit's different. We're talking about percentages and increases. And yes, insurance goes up for everyone. Insurance goes, there's insurance for apartments, there's insurance for everything. And justification of those, you're saying it as a generalization, we're saying as renters to justify that. And I don't think that's unreasonable. And you're saying all the good things, but sadly, that's not the reality. Like, you're saying a lot, you're saying this is good business, but the reality is good business isn't happening. It's not happening. So I just wanted to respond to what you said. I don't want to have it back, but it's not happening. I know the units you're at. I know the tenants that live there, and it's not happening. I'm glad to hear you say that maintenance and that those increases, but I would really appreciate that what you're saying matches what the reality is for tenants, and that's why I'll leave it at.
Okay, we're going to agree to disagree at this point.
No, that's fine.
Okay?
That's fantastic.
All
Thank
right.
you. I appreciate the
Thank
time.
you for your testimony.
Thank you.
Harry Bilodeau, Maddie Patty, Alex Gonzalez. Anybody here? Sam Levy. Come on up. How about Chris Smith? Come on up. So we got Sam.
Gentlemen, hi. Let's go that way. Go ahead. And we're trying to keep it on a 2-minute typer. Keep it short and hit your points. Appreciate you coming.
Good to go? All right. I'll do my best. I didn't prepare a speech, but my name is Matthew Patty. I'm a real estate broker and a real estate investor as well. And, you know, I listened to a lot of the testimony because I wanted to hear what people were saying and then kind of respond to it. And I knew which side of the landlord-tenant advocacy side I fall upon. There was a gentleman who was speaking early on, and one of the chair people asked him some really logical questions, like what are the numbers that support rent control? Does it decrease homelessness? I'll say this. There's 2 ways to decrease homelessness. I'll give you an example. There's a homeless kid living outside of one of my buildings in a car right now. His mother threw him on the street and told him to live in a car. So I'm trying my best to help him out. I wish I had more time to do this, but that's one way to help with homelessness, is to try to advocate for people who are actually homeless. The second way is to look at the data. It was very, very striking to me that the gentleman who responded, the younger senator or legislator, said, we can't look at the data. You have to look at the data. It's the only way to help with homelessness, is to look at the data. If you're a legislature, you're in charge of a huge organization, a huge state, the state of Rhode Island, and everywhere rent control has been enacted, in every city, in every place. Look at New York City. Look at what New York City is like. You have the widest diaspora between rich and poor. You have people who are living in project housing in unsafe conditions a few miles from $60 million apartments that people from out of the country buy just for speculation. So you have to look at the actual cause and effect relationship between rent control, banks, lenders pulling out, small investors like the immigrant gentleman who was here pulling out, being replaced by state agencies that quite frankly do a poor job of doing the thing that local landlords will do. So in conclusion, I would like to say that the people proposing rent control are coming from a good place. But when you come from a place of saying, I can't look at the data, that's a bad place to be advocating from.
Thank you. I appreciate it.
We look at the data. We know what you're talking about. It may not, we really can't discuss it here tonight because it will be here till midnight and whatever, but I understand what's happened in the 6 states that have had rent control, and I understand what happened in Cambridge, Mass., and I understand what happened in New York and San Francisco. So I don't want you to think that people here aren't, we're pulling a blind eye to that. That's not the case, okay?
I thank you for that, sir.
That's all right.
Do me a favor, will you turn off your mic there so we don't get the feedback? Sir, tell us what your name is in 2 minutes, please.
My name is Sam Levy. I'll try and keep this as short as possible. I'm a member of Rhode Island Coalition of Housing Providers, and I'm retired, and my rent is my income. or my rents are my income. The one thing that came up before that I really have a problem with is about lead. Anything from 78 and before should be tested. That means anything and everything. This building, schools, whatever. Anything that's there's an exemption for owner-occupied houses. If you own a single-family house and you're a father, grandfather, great-grandfather, your kids come over, their kids come over, and it's a single-family house, you're exempt. Those kids are all exposed to lead. To put it on just on landlords, I think it's double standard and hypocritical. To say anything whatsoever about having a landlord, that a landlord is required to do it is, I'm repeating myself, double standard. Every single building in the state should be checked, period, without exception. And if it was before 78, 79, that should be checked. Anything newer should not be checked. And, I've put in, emailed and the form and stuff like that you guys have. So, thank you very much for being here.
Thank you, Sam, for your testimony. We appreciate it. Sir, Sam, will you shut up? There you go. And, sir, tell us your name and...
My name is Christopher Smith. I'm a small owner-occupied landlord. I want to speak to a few of these points. The first one being, since the rep had brought it up that there was no actual cases, my taxes increased my mortgage over $400 a month less than 6 months ago.
What town?
East Providence.
Okay.
I split the cost with the tenant. They're paying $200 more. I'm eating $200 of the cost. Under a provision like rent control with a 4% limited cap, I would have only been able to increase their rent $60, which means I would be paying another $340 a month. I don't see how that's fair. The stove and the refrigerator in their apartment came up on the 10-year mark, and that's pretty much what appliances do nowadays. So I had to replace those. That was over $2,000. 4% cap, any cap is crazy. I don't know what body, if any body, should be determining what's fair. Markets determine what prices are. The other thing I wanted to speak to was month-to-month rental. My tenant's a month-to-month. They've been there over 3 years. I don't see a problem with a contract between two people, and I don't see why the state needs to get involved. Gentleman that spoke previously, it was right. It is expensive when tenants leave. The walls are going to need paint. Things are going to need to be, not that they don't need to be redone while they're there, but when someone moves out, it all has to be done at once, and it's expensive, and you're losing money the whole time. The lead laws that were pushed or passed through, passed. I'd like to see some kind of provision that if the lead is removed from the house, that you no longer need testing. Half of my house has been gutted and redone, and the other half, all the windows had been removed, all the moldings, and sheetrock was put over the horsehair lead. So I believe I don't have lead anymore, but under...
Don't you get a certificate for that?
I'm not sure at this point. I don't. I'm not that. I don't have a team of lawyers working on this. So
no,
it has to be renewed a lot of the time, especially if you're participating with state agencies. And you can fail a lead inspection because your tenants work around and get junk on their feet and put dust all over the place too. You can build a house in 2026 and fail a lead inspection because if you get a certificate, but then you have to renew it, kind of.
How often?
I think it's every 2 years, and so especially if you're, I'll work with the housing authorities. I believe in that. Affordable housing, I believe, is a great initiative as well. And if you're working with the housing authority, there's the ones who are going to make you comply. And unfortunately, some housing authority tenants are great, and other housing authority tenants are trashing the place. My homeless kid living in my driveway, his mother was a housing authority tenant. We evicted her even though she was paying because she was destroying the place and menacing the other tenants. And so that place would not pass a lead inspection just because of garbage and dirt and foul things on the floor, and we've cleaned it
All
all
right,
up.
we got you.
know.
Thank you very much. For people watching at home, you got to get it. You got to redo your lead certificate every 2 years, and that's an opportunity for some legislation that we've talked about before. Do me a favor, shut off your mic.
So if the lead were to be removed, or if there was a way to test, which I believe there's a machine that they can shoot the walls with, some kind of laser, and they don't find lead, I think at that point you shouldn't have to retest every 2 years.
Thank you. I appreciate your testimony.
Well, we have single families that we're not testing at all. So like you
Okay.
said,
Thanks, guys. Appreciate it. Thank you. All right, next three. Can we have, please, Henry Bilodeau? If you're, do me a favor, if you're in the room, raise your hand so I know you're coming up. Robert Mangilo, Lisa Kirsch, or Kitson, Critch, Krctsch. You're not speaking. Okay, great. Well, who are you, sir? Are you? Do you wish to speak? Then come on up. You can take Lisa's place. How about Robert Mangilo or Henry Bilodeau? Going once. Going twice. Okay. Ivana George, come on up. And, oh, Chris, there you are. Look at that. So, Lisa, your testimony is noted for the record. And Dawn Sousa, not testifying. Angelo Rapsamalis. There you go. Did I say it right? Sort of. Okay, so try to keep it to 2 minutes. I appreciate that there's a lot of detail here. And turn your mic on, green, and go.
Hello, House Committee. Thank you for having me here tonight. My name is Chris Kretsch, and I'm a small owner-occupant landlord in Providence. I want to talk about a couple of the issues. Credit history limit for 3 years. I currently use a background screening and reporting tool via Zillow, and I don't control the number of years it shows me. It's built in. It's a very easy-to-use function. It works for tenants very well. It works for me as well. The tenants can also see a copy of their credit report, so if there are any blemishes, mistakes, fraudulent or otherwise, or even just a bad, like if they had a medical debt payment problem in the past that has been resolved and they want to proactively bring it to my attention, they certainly can. And I can make a reasonable accommodation for that. Where I get really worried about this law is that even just failing to return a rejection in 20 days could lead me to a referral to get to the human rights courts of Rhode Island for a human rights violation. There are also tools on Zillow that allow tenants to apply with a single click, and sometimes I get lots of applications where the tenant never even messages me to respond. So just not responding to them within 20 days could open me up to someone just abusing the system, applying to 1,000 apartments, and then referring however many landlords they want to the Rhode Island Rhode Island Human Rights Court, and it's just going to make landlords look bad, but it's really just going to be a gaping loophole in this bill. Next, I want to talk about interest-bearing savings. All my security deposits are in a savings account. They're separate of my own personal finances. They are FDIC insured. For 6 units total, January it produced 18 cents for all 6 units, and in February it produced 16 cents of interest for all 6 units. The administrative burden for me to keep track of that for each unit is much more than it's even worth. I'd rather just give the tenants more than the interest. Fair housing protection for formerly incarcerated people. Incarceration is a valid business case for rejecting a tenant. It does not deserve the same protections as gender, race, or religion. If someone wants to demonstrate that they've served their debt to society, they are perfectly able to submit in their application that they've done community service, that they've worked, that they've demonstrated a certain number of years and repaid their debt, and they can put that in the application just like job experience, and I can take that into consideration.
Thank you.
However, hiding it is not something my tenants want, and they want me to be able to consider something like that. They want me to know who's in the building.
Thank you very much. Do you have, what's that? Yeah, I mean, I got you. Go ahead, ma'am.
Hi, my name is Ivana George, and I'm a rental property owner in Rhode Island as of Monday. I would like to express opposition to House Bills 8108 and 8109. And to share my personal story so you can understand the unintended consequences that if these bills are passed together, they would bring. This legislation should be understood as a policy detrimental to the state economy, not a housing provider and tenant disagreement. Policies that regulate housing prices, alter incentives across the entire housing market, influencing investment, maintenance, lending, insurance, underwriting, and ultimately whether additional housing is even created in Rhode Island. This is not a solution to the affordable housing shortage. Effective solutions would be to change restrictive zoning laws statewide, policy to encourage more development of market rate and affordable housing, expand housing opportunities with state policy, and directly assist residents who are in actual need. I'm an artist and art professor from the state of Massachusetts. 8 years ago, I set a goal to make an investment in residential real estate as part of my retirement planning. After doing careful research, I chose Rhode Island to invest in because of the fair and balanced housing laws on the books, compared to Massachusetts, where laws heavily favor tenant rights over housing providers' rights. After saving for years, I closed on my first investment property in Pawtucket, Rhode Island on Monday. It's a 6-unit apartment building constructed in 1910. Due to its age and somewhat neglectful management by the prior owner, it's in need of apartment renovations and exterior maintenance. I purchased this property with the intention of rehabilitating the dilapidated property and providing affordable housing by renting it out at HUD fair market rents. I don't intend to reside in the property. However, if H 8109 were to be passed, I would not be able to remove the tenants from the units that need to be renovated at the end of their lease. That means I would not be able to renovate the apartment until that tenant decided to leave on their own or committed an act which qualified them to be evicted under the statutes. If the legislature passes rent control with just cause eviction, it will limit housing providers' financial capacity and incentive to upgrade and maintain the housing stock in Rhode Island. Do you want to drive small housing providers like me away from the state?
Thank you.
Furthermore, the language in these rent control bills does not account for situations when a property is sold and the prior owner of a property did not raise rents to keep pace with inflation. I purchased the property for $755,000. The prior owner purchased it for $975,000 in 2018. Huh? Yes? Oh, my time's up. I'll submit the rest of my testimony by
awesome.
email.
Yeah, and hey, congratulations
Oh,
on your
thanks.
new venture.
Thanks.
All right, do me a favor. Yeah, press your button there. All right, Angelo, you're on.
Hey, good evening, committee members. Thank you again for having us here. My name is Angelo Capsamalis. I'm a member of the Coalition of the Housing Providers. I'm here to oppose, most of these bills. I've been up here for over 5 years opposing the same kind of bills. I'm against rent control, just cause eviction. But tonight I want to keep it positive and just talk about, the bills that I am actually supporting. So, yeah, bill number 7560 by Rep. Casey. This is about the lead bill that was passed a few years ago. It definitely needs some adjustments and provisions. As it is right now, if a tenant goes online, finds out that your lead certificate expired, he doesn't have to pay rent to you, and you cannot evict them for non-payment of rent. This is a very counterproductive measure where over 90% of the evictions in the state are due to non-payment of rent. So now I cannot even file an eviction because my lead certificate expired or I don't have a lead certificate for that unit. That's why we need to make some adjustments. If the issue is about lead, which it's never about lead most of the time, it's always other issues, then, they can put, the rent in escrow. The property owner goes, addresses, gets the place lead certified, and so on. But currently I cannot file any evictions at all if I don't have any lead certificates, and the people get to stay there for free without paying me rent. And it's just a counterproductive measure. I'm also want to talk a little bit about the anti-squatter bills by Rep. Baginski, which is very important to have those protections. These are all common sense protections passed by many states. We have many, landlords that have some units open. They either advertise them or they're under construction. People found out about them. They get in there, and then it's very hard impossible to get them out without wasting 3, 4, 5 months lengthy evictions. And also people that are putting houses on MLS for sale that are having the same issues. So I think we need to pass some protection for that. Thank you again for having me.
Thank you, Angelo. I appreciate it. Thank you so much. All right. Homestretch. And, ma'am, that's a good point about rehabbing an apartment. Thank you for that.
Thank you. Yeah, I was just trying to, if you don't mind, can I just finish that, my thought on that?
Real quick.
So the current rents are at HUD 2021 fair market rents. The prior owner purchased it for $375,000. So that owner's mortgage expenses were much lower than mine. And this is a common scenario where an owner takes a minimal maintenance posture on an old rundown building and chooses not to raise rents in order to prevent tenant turnover. But then when the building is sold, the rents are insufficient to support the debt on the new sales price, which is the case for the building I purchased. So it wouldn't qualify for financing, and I had to use my HELOC plus cash that I have. Now I have to rehab the property, raise the rents to current HUD fair market rent values, and it's probably going to have some turnover as a result. But that's what I have to do in order to go get financing, because I can't keep this on my HELOC forever.
Thank you.
Yeah.
Okay, next three. Here we go. Anthony Thompson, are you in the room? All right. Megan Comella? Megan Comella. Okay. Opposed but not speaking. Carrie Doyle? Ms. Doyle. Is there anyone in the overflow room, do we know? Okay, so this is it. Great. Well, I have a whole list of people. We'll get to you. All right, I'm just going right here down the list that was handed me by our very, very capable clerk. All right, Carrie Doyle going once. Deanne Guo, come on up. And Callie McDonald. All right. Okay. Ma'am in the green shirt, who are you? Okay. Excuse me? All right, I was looking for Callie with an L. All right, great. All right, going this way. You're first. So 2 minutes, and keep it tight, and tell us what you know, please.
All right, my name is Anthony Thompson. I'm part of the Rhode Island Coalition of Housing Providers, and I support and oppose the same bills that they do. For the sake of time, I'm just going to speak on a few bills. I support 8112 because it increases flexibility for housing providers and tenants, helping less qualified tenants who might not have met other criteria in the application process to still get their applications approved by letting them offer additional assurance to the housing provider. It's common for tenants to tell their landlord to apply the security deposit to the last month's rent, effectively leaving many housing providers with no real security deposit at all. Cost to repair damages have, like many costs, risen substantially over the last few years, and in that scenario, without this bill, repair costs have to be passed on to the next tenant in the form of higher rent. This bill addresses that issue and makes sure a security deposit is used for security and not last month's rent. If there are damages, they can be paid out of the security deposit of the departing tenant who caused them, rather than passed on to the next one. And if there are no damages, the security deposit can be returned as it has always been. It also allows tenants with weaker applications to offer additional security beyond 1 month's rent to further strengthen their applications if desired. This bill does not require, but merely allows, a housing provider to collect last month's rent in addition to first month's rent and security deposit. It is simply an additional factor that can allow some tenants who might have credit or income challenges to secure rental housing. I oppose 7758 because existing law strikes a fair balance in that if a tenant brings any pest into a building and their unit is the only one with the pest, they have a responsibility to address the issue. But as soon as it spreads to other units, it becomes a building issue and the landlord's responsibility. I think this is a very fair way to handle it, and I don't think there should be a special exception made for bed bugs compared to other pests. I oppose 7762 because landlords already give less weight to older items on credit reports, and I think 3 years is much too short a time period to consider. Also, many landlords don't get full credit reports at all, just a credit score, and would have no way to know if their credit score service would violate this law unknowingly. This might mean that they might not be able to consider credit at all, which would not allow them to screen for financial ability, and I don't think is the intention of this law. Lastly, there is already a requirement under the Fair Credit Reporting Act to notify tenants if they are denied for credit reasons, so that's another reason this law is not necessary. Thank you for your time.
Score. Good job. Thank you very much. Do me a favor, turn off your mic. And go ahead, right down the line. Deanne?
Yes.
Thank you for coming to the House Judiciary. Tell us what you know.
Thank you for your time, committee members. My name is Deanne Guo, and I'm a community organizer with the Childhood Lead Action Project. So I'll be speaking on behalf of those lead bills. And we do oppose both lead bills 7559 and 7560. Versions of these bills were introduced last year, and the General Assembly chose to maintain our lead protections for Rhode Islanders, and we urge you to do the same again this year. As for 7560, adding an exemption from lead safety requirements for rental properties that do not house an at-risk occupant is illogical. I will kind of highlight what Rep. Bielik said. Children do not stay in one home for their entire childhood. They might visit family and friends. Families do move, and people who are not currently pregnant may choose to have children. Also, while it is true that younger children are the most at risk for lead poisoning, lead is a toxin that can negatively impact neurological, cardiovascular, and reproductive health in all members of a household, from older children to adults to even pets. This proposal, as Rep. Agello said, would also unintentionally lead to the quiet discrimination against families with children looking to rent as a way for landlords to skirt around the lead inspection requirement. As for the rental registry, this is something that the General Assembly passed in 2023, and it was a good decision, and it's already really working. The rate of lead certificate issuances per month have more than doubled, and thousands of units have been made lead safe. The benefit of the registry, though, goes beyond lead safety. It is a transparency and consumer protection measure, and we have a business registry that this is no more invasive in terms of information collected and shared with the public. The rent non-eviction due to non-payment of rent is also something that is extremely important and is key to the power of the legislation. We should not walk it back.
Thank you very much for your testimony. I appreciate it. If you do me a favor, turn off your mic, and Ms. McDonald-Kelly, will you go ahead?
I will. Thank you. And good evening, members of the Judiciary. It is my hope that the representatives here today have the goal of helping people stay in their homes longer. House Bill 7765, 7764, and 8108 seek to do just that. Empirical evidence in New Jersey, California, and Massachusetts demonstrate that rent stabilization bills like that of the 4% cap allow tenants to stay in their homes longer. Further, eliminating algorithmic pricing and increasing the notification time for rent increases allows renters a greater sense of stability in their home. Increased stability in homes will have positive impacts for all of Rhode Islanders, not just renters. Increased stability has led to increased economic mobility, employment retention, improved mental health outcomes, and improved attendance in schools. I've seen neighbors who have lived in their homes for 30 years raise their children there to be forced out because a landlord decided to raise the rent 50% without making any property improvements. I know costs are increasing, but not at 50% in a year, and I know our salaries did not increase 50% in that year. The landlords speaking today are well organized and well funded. They will talk about the threats they face by increasing tenant rights, when really these are proposed measures are moderate to balance the medieval power imbalance that exists between tenants and landlords in Rhode Island. Lastly, I'd like to ask all of the self-proclaimed good landlords that are present tonight to provide references to the quality of their properties so we don't just need to rely on their good faith arguments. Thank you.
Thank you for your testimony. I appreciate it. Okay, next three. Here we go. James Field, come on up. Tizreine, Tizreine, Pardo. Is that you, sir? Yes. Come on up. Jeremy Costa. Did I say that right? Tizreine?
Sorry, it's Thesiano.
Thesiano, sorry. My bad.
No, you're all good. My handwriting might have happened.
All right. Mr. Costa, will you do me a favor? Shut off that mic there so we don't get feedback. Excellent. Thank you. Go ahead.
Great. Good evening, Chairwoman McEntee and distinguished members of the House Judiciary Committee. My name is Thesiano Pardo, and I'm a student at Brown University. I'm also the co-lead for the Brown Initiative for Policies, Housing Opportunities Made Equitable team. Today, I speak before you to express my strong support for House Bill 7764 and my strong opposition to House Bill 8112. House Bill 7764 seeks to stifle the mounting cost of rent by breaking up hidden landlord oligopolies and returning competition to the renter marketplace. Algorithmic pricing tools like RealPage's YieldStar allow landlords to use non-public data from other landlords to set their rents. In practice, this causes landlords covering a shared market to artificially inflate their prices based on insider knowledge unavailable to the public, effectively creating an informal cartel. House Bill 7764 promotes free market competition among landlords that will reduce inflated rent prices. The bill maintains exceptions for internal record keeping and accounting so businesses can still use their own proprietary data when determining rent. Additionally, any publicly available data, including listings on marketplaces, can still be factored into a landlord's decision. With the bill going into effect in January 2027, landlords have plenty of time to adjust their current practices to comply with state law. House Bill 8112 seeks to raise the maximum amount a security deposit can charge from 1 month to 2 months' rent. This is stripping tenants away from their ability to sign on to a new apartment, let alone even afford that unit in the first place. As of March 2026, the average rent in Rhode Island is $1,834. Should House Bill 8112 pass, the General Assembly would allow landlords to charge up to $3,668 for a security deposit. This is not even factoring in the common practices for tenants to pay for the security deposit on top of the first month's rent, which would bring the cost up to $5,502. This effect is most staggering in our capital city of Providence, which would allow tenants to pay up to $6,231. And for those reasons, I ask you to oppose this bill. Thank you.
Thank you very much for your cogent testimony. We appreciate it. Mr. Costa.
Good evening, committee. As you guys know, my name is Jeremy Costa. I'm also a resident of Rhode Island, and I have mixed feelings about a lot of these bills. So I'm going to be honest with you. I'm going to take a little bit more than 2 minutes, but that's okay. And
Mr. Costa,
that's understandable. That's understandable. Thank you.
Go ahead. Use them how you will.
The first thing that I want to say is that when we're discussing housing policies, we need to make sure that we are being grounded in truth, fairness, and humility. You know, when we try to solve a complex issue with policies that ignore economics, we risk building systems that feel compassionate but ultimately fail the very people that we want to help. The real issue in Rhode Island is not simply rent levels, and I do not hear one bill that actually addresses families, home ownership, and that's the real issue for me, and that's the real issue for Rhode Islanders, I believe. 22 bills today, and we're focused on regulating landlords and tenants, and we have an income and supply issue. You know, it's kind of disheartening for me. You know, today, you know, houses cost, you know, in the city of Providence, it costs for 3,500 square foot lot, it costs $200,000. That's just for the lot. That's just for somebody to put their tent in the lot. You know, it costs $200 a square foot, per square foot right now because of the cost of living, you know. So I really wanted to continue reading this, but I want you guys to understand that there is no affordable housing right now. I don't care where you are in the state of Rhode Island. You know, I'm looking at properties in Tiverton and other places, and you can't find affordability. So what we need to do is we need to start carving out opportunities with the federal government. Since we get, for every dollar we put in the system, we get 4 back, we need to start carving out like good neighbor programs. We need to start carving out opportunities. We do not need to be trying to go after landlords and other people that really are not cause of the issue. The cause of the issues are the policies that are causing all the problems.
Thank you.
So what we need to do, number one, is
Mr. Costa.
we need to really take a look at some of these bills. No, I understand, Mr.
Please submit it in writing.
No. So I can submit it in writing. You'll still accept it and read what I'm going to submit?
Absolutely.
Wonderful. But I do want to say one thing, because I believe that this is an issue that everybody's talking about. We need to update our system in our state. We need to get familiar with technology. It's very important. There's no reason why you put in that you clear somebody 2 years and then they got to go back and front. This is bureaucracy that we got to start to eliminate. We have to start to eliminate. We have to use technology. It is vitally important. I will respect and not get removed from this room right now, but I'm just saying it is very important. We need to come together. We need to stop trying to, you know, just do all these bills just because it sounds good, you know, for political seasons. That's it. Thank you.
Thank you, Mr. Costa. We appreciate it. And do me a favor. Will you turn off your mic, please?
Sure.
It's the feedback issue. Awesome. Sir, go ahead.
Good evening, Chairwoman and members of the committee. My name is James Field, and I live in West Warwick. I submitted written testimony supporting the large package of tenant bills today, but I want to focus my time on 4 critical pieces of legislation. In my daily work at a call center, I hear how stressed Rhode Islanders are about housing. HB 8108 and HB 8109 are survival tools for working people. Capping rent increases and requiring a just cause for eviction ensure that good tenants aren't arbitrarily forced out onto the streets. And we need those protections to stay in our homes because the cost of finding a new one is out of control. Like a lot of renters, I already know I probably won't get my security deposit back when I move. It just disappears. HB 8113 fixes that by forcing landlords to treat our money with the accountability it deserves in an interest-bearing account. On the other hand, HB 8112 would be a disaster. If I lost my apartment today, a new landlord asked me for first month's rent, last month's rent, and 2 months of security deposit that HB 8112 allows, I could not afford to move. I would be priced out of having a roof over my head. We need 8108 and 8109 to keep us in our homes, and we need you to reject 8112 because working people cannot afford thousands of dollars just to get the keys to a new apartment. Please pass these tenant protections. Thank you.
Thank you very much. I really appreciate it. Thank you all three for your testimony, compelling testimony.
You had no questions? Like, there was some great commentary here, and you had no questions for nobody, especially this young gentleman here. That's a serious issue. No commentary? All right, no questions? Thank you.
Thank you, Jeremy. All right, next 3. Here we go. Raya Srinvasan. Did I even get it close? There you go. James Murray. Mr. Murray. And Greg Wes?
Oh, he already went up.
Did he already go up?
We already had him.
All right, great. Sorry, old eyes. Kate Shapira? Are you Kate? Yeah. James Murray? No James Murray. Going once, going twice. Okay. So here, Vivian Sutherland?
She's here.
Very good. Okay. Starting from that end, going that end. Tell us what you know. Thank you for coming to House Judiciary.
Hi, thank you so much. Hi, Chair and members of the House Judiciary Committee. My name is Ria Srinivasan, and I am also with the Brown Initiative for Policy, and I focus on affordable housing, and I am speaking today in support of House Bill 8109 for just cause evictions. As we know, Rhode Island is in a housing emergency, but what makes the crisis worse is that Rhode Island renters have almost no protection from arbitrary displacement from their homes. Right now, a tenant who pays rent on time, follows every rule, calls their landlord to fix a broken heater can be evicted for no reason at all. I think Representative Cruz said it best. Tenants doing everything right only to be threatened with removal the moment they ask for basic repairs. This is just not a system that works for Rhode Islanders. This is a system that works against them. In just 7 months, in 2023, over 4,000 evictions were filed in Rhode Island. Providence alone has seen more than 24,000 evictions since 2020. Nationally, households with children are twice as likely as other households to be threatened with eviction, and black renters are about 5 times more as likely to be evicted than white renters. Rhode Island mirrors these patterns. I know that building more housing is a great part of this conversation, and I'm not here to dismiss that. But I wonder why Rhode Island is so focused on what we're going to build tomorrow when people are being kicked out of their homes today. What good is new development if the people who have lived in these communities for years, for decades, are being displaced before a single new unit is ever completed? We cannot build our way out of this crisis while simultaneously allowing the ground to be pulled out from under us. It starts here with tenant protections. Just cause eviction legislation would change that. It requires landlords to have legitimate reason before removing a tenant. And research backs this up. Emerging evidence finds no significant negative impact of just cause protections on housing productions, contrary to what landlords may say today. But what these protections do produce is stability, and this is the most powerful determinant of health, educational outcomes, and economic mobility that we know of in Rhode Island. Nearly 40% of Rhode Islanders here rent their homes. That's almost half of y'all's constituents. And so I urge y'all to pass this just cause eviction protections, because it all starts with the vote you cast in this room.
Thank you very much for your testimony. Do me a favor, shut off your mic. All right, Kate, you're up.
Thank you. Thank you, Madam Chair. Thank you to the committee. My name is Kate Shapira. I've lived in Providence for 23 years, 9 of those as a renter and 14 as a homeowner. So I've lived in Federal Hill the entire time, and I've seen many of my neighbors be priced out by rent increases. I'm going to focus on bills 8108 and 8109 with a couple of questions. The first is that many people here tonight have claimed that stabilizing rents has a chilling effect on building housing, but we don't have rent stabilization now. Why aren't apartments going up like crazy? I think the answer lies in the fact that we haven't yet put in place many of the provisions that the sponsor of the bill mentioned in his testimony, many of which I believe Ms. George also mentioned as solutions to the problem of insufficient housing in the state. Changes to zoning, changes to other regulations, serious investment in building new housing. That's what we need. But we also need rent stabilization for the people who are here and the people who will move here to live in those buildings. The other thing is that last night I was in City Hall listening to testimony on this topic, and a lot of landlords at that time, as well as at least one person who was in this room earlier, were describing things that impacted them or that they were afraid would impact them as facts, and things that are currently impacting tenants as feelings. And that doesn't make sense to me. Your hardship is a fact, but their hardship is a feeling. It's just emotional. It's just humanitarian. I think that we can agree that losing what you have is frightening, but as one of the bill's sponsors pointed out, there's a difference between what you need for comfort and what you need for safety, dignity, and stability. Stable rent in 8108 and eviction protections in 8109 will keep more Rhode Islanders safe, they will keep more Rhode Islanders housed, they will keep work and schooling stable, and by doing so will improve the overall present and future of our state. Thank you so much for your time.
Thank you very much. Your notes about stability, providing the basis for a healthy life, and are well taken. We know that. Thank you. Do me a favor, shut off your mic, please. Vivian?
Hello, and thank you for hearing us today. I originally wrote a whole speech, but I figured I'd just talk plain with you all.
We prefer that.
Yeah, especially since it's omnibus and everything. So thinking about this, often we're talking about the housing crisis, production crisis, supply, demand, all that. I think we need to recognize that the issue is not just a supply of the buildings and how tall they can go and make as many units as possible, but we're dealing with the fact that there's a supply issue for land. Most of the land is already owned in this country and has been for like almost 150 to possibly 200 years. And so, just doing a quick search on the internet, only 26% of the population actually owns their home outright. I think that's also why we see so many of these struggling small mom and pop landlords who, are just trying to pay their mortgage. And I think that this is like a thing that we don't think about enough. It's the land that has the value, and as long as that land continues to be valuable, especially in a place like Rhode Island where everyone wants to be near the nice coastline, those rents are going to continue to go up because the ultimate value of the land is going to continue to be valuable, so the ground rent is going to continue to be extremely high. You look at any tax assessment database, it's always, the land rent or the land price is way higher than the house value. So we could build up and up and up, but if the land is continued to be valuable, there's going to be upward pressure on rents and on housing prices. And so, that's the fact of the housing crisis, but you all are, the House Judiciary Committee. You're about what's actually happening between the landlord-tenant relationship, especially in court. And so I think what people are asking for here is that for a very long time, all the way, 100 years ago, 200 years ago, the tenant-landlord relationship has been unbalanced. We all know how tenancy became a thing. Originally we thought, all these people were settling in America, they could go across the frontier, they could become, small farmers or small property owners, but eventually the land ran out, like I was just saying. And so people were forced to become workers, work in the cities with industrialization and things like that. But now that we see that it's really unprofitable to make a living, in big business, things have moved to financialization. And so because it's so unprofitable to start new business, I'll just end it there, that is why we're seeing this financialization of housing, because real estate, we all know it, will make you a lot of money, and until we can actually regulate things, the building is not going to be enough. We need to do those stopgaps. I would be in favor of actually freezing the rent as an emergency measure, since someone said that earlier.
Thank you.
Yeah.
Just
Go ahead.
a quick comment. I just want to thank you for bringing up the point, too, about, why didn't we build? We didn't have tenant protections, and you talked about we haven't built. We were the lowest in the country for building since FDR, right? We haven't built in Rhode Island. But places like California and the other states that have just cause eviction protections actually had boom in building for years, and that's empirical, that's research data. So I just want to thank you for bringing up that point and expand on it, that when we start to hear the fear narrative, the fear mongering, that building, that actually doesn't bear out in the research. So thank you for bringing it up.
Thank you, everyone, for your testimony. Thank you for coming to Judiciary. All right, next three. Please raise your hand if I call your name. Siraj Sindhu? No Siraj. Okay. Alexander Brown? Come on up. Donald King? No Donald King. Siru's going once, going twice. And Donald King going once, going twice. Grace Hanson? Grace? Is there a Grace Hanson out there? Ivana George? Ivana George? Nope. All right. Madam Clerk, this is everybody? Okay.
These guys want to.
Well, hang on. There's an order, there's a system. All right, just have a seat. We will get to you. If you don't feel like you got to stay, if you want to email your testimony and jet, you can do that too. All right. Matt begins with a P. Patsy, perhaps? You already testified. All right. There you go. All right. Christopher Keach? Kretsch? All right. Dominic Passarella?
Come on up.
I'm better with the Italian names. And Nelson Monia? Nelson, is it? All right. Hannah Moore. Hannah Moore. Negative. Chris Huptfeld. Come on up.
There he is.
All right, so it looks to me like I have Dominic, Chris, and Alexander. Is that correct? All right, Alexander, why don't you start? We'll go this way. 2 minutes. Tell us what you know.
Good evening, and thank you for hearing my testimony. My name is Alexander Brown. I own 7 rental units across 2 properties in Rhode Island, one of which I personally reside in. Please go ahead and ask any of my tenants for the person who was here before that was asking about how great their landlord is. Ask any of my tenants, they'll say I'm the best landlord they've ever had. I'd like to speak in regards to the regulations on the price of rent, capping rent at 4%. My question, to go outside of what people have already discussed, is who is regulating a 4% cap on increases to sewer, water, electricity, or gas? Because the Public Utilities Commission is not regulating those increases to 4%. However, those utilities are increasing more than 4%, and I'm sure all the landlords in the room will mirror that sentiment. Additionally, most people, constituents in the state of Rhode Island, would probably also mirror that sentiment, that those prices are increasing for individual homeowners as well, more than 4%. Beyond that, insurance in recent years is especially driving up the cost of housing, again, more than 4%. Additionally, taxes have driven up the cost of housing more than 4%. At my property in West Warwick, last year I was assessed almost a 40% increase on taxes on that property. Those costs were largely passed on to the tenants who did not have Section 8 rental housing assistance. who, by the way, declined any increase in rental payment and forces me to consider if I will keep that tenant beyond the end of their lease.
Hang on for a minute. We got a window situation. If you just put your foot on there.
Just make sure that timer's on
Yeah, I
pause
got you.
over there.
I got you. Matt, if you put your foot on it, you'll just, you don't want to break, I know. All right. We're not gonna dock you. We just want to get this window situation figured out. There you go. Excellent.
I'll keep it respectful
Boom.
and under wraps,
All right.
I swear.
That is, ladies and gentlemen, that is State Representative.
I'd like it on the
Ross.
record that we sent them jumping out the window on the testimony.
How many state legislators does it take to shut a window? Go ahead, finish up, sir.
Thank you. I'd like to note the people who aren't here to oppose some of this legislation. The major slumlords in this state, who I will not name, but I have purchased properties from and rehabilitated. They find ways to get around any laws that this legislature passes, including ways such as enforcing 12-month leases that expire at the end of the lease, allowing the landlord to raise the rent or kick the tenant out, foregoing any other restrictions by legislation, cash for keys arrangements, which are all legal ways to get around the law and would also likely still be legal if these laws or bills are passed. I'd like to point to a great point that the young man Sebastian made regarding monopolistic practices of corporate landlords. I've mentioned that I am a small landlord with only 2 properties, and I'd like to point out that regulated monopolies such as Rhode Island Energy are not being well held in check by the current system. I have more to say, but I'll email it. Thank you for your
I
time.
appreciate that for sure. Thank you. Mr. Passarella?
Thank you guys for staying late and hearing us out. My name is Dominic Passarella. I'm a landlord in Providence, and I oppose rent control. I want to highlight an unintended consequence that I hope you will consider. The specific concern I want to raise tonight is that rent control may actually increase rents more than they otherwise would for the most vulnerable tenants. I have a tenant who lives and cares for her adult daughter who has severe brain damage. She has lived in my 3-family home since I purchased it in 2008. Because of her situation, I have always kept her rent well below market value. My assumption was that I could bring up the rent to market values once she eventually moved out. The ordinance would take away that flexibility. Her current rent is $11.25 for a 3-bedroom apartment. It's only that high because I became concerned when rent control was proposed here a couple years ago. For comparison, the Section 8 standard for the similar unit would be around $1,900. If rent control passes and I do not raise her rent by the maximum allowed each year, the unit will fall even more below market rent by the time it comes available again. This makes it much harder to continue offering below market rents to long-term tenants. It forces me to choose between being generous to my tenants and protecting my own family's financial future, since failing to raise rents will reduce the property's value when I sell it. Allowing rents to reset, even to something like the 25th percentile of comparable units upon tenant turnover, would help landlords continue providing good value to tenants. At that level, it would not create an incentive for landlords to terminate leases just to raise rent. I understand there could be someone to petition to adjust to market rate, but it would be too big of a gamble for an uncertain outcome. Thank you.
Thank you. Chris?
Hi, I'm Chris Hoffeld. I'm thrilled to speak in favor of a number of the bills tonight, especially 8108, 8109, and 7764. I'd like to talk about the gravity of the situation. The Department of Housing and Urban Development defines someone as housing cost burdened if they spend 30% or more of their income on their housing. There's been broad consensus on that definition for about 100 years. When housing costs are more than that, it gets harder to afford food, harder to afford medicine, and harder to afford other necessities. It's a situation which nobody wants to, nobody deserves to be in. So now let's compare. On one hand, we can look at what the median or typical Rhode Islander earns, and on the other hand, we can look at what the median or typical Rhode Islander spends on housing. And we can see whether the second number is 30% or more than the first number, or if it's less than 30% of the first number. There have been studies which look at every city and every town in Rhode Island. They make the comparison for renters versus for homeowners, and here are the results. The typical renter was housing cost burdened in every single city and town in the state of Rhode Island, except for one, Burrillville. The typical homeowner was housing cost burdened in every single town and city in Rhode Island, even Burrillville. In Providence, rent has risen 40% since 2020, and in that time, there have been 24,000 evictions. Why should everyday Rhode Islanders be put in a situation where they have to choose between a roof over their head and food? I ask you why. I'm in support of these bills because we shouldn't have to make that choice. These bills make it easier for Rhode Islanders to support their housing, and if anything, I would encourage you to make them even stronger. Thank you.
Thank you very much for your testimony. I really appreciate it. Okay, I got 4 left, so if you hear your name, come on up. Alexandra Genzeller, perhaps? No? Jimmy Murray? Danny Vallejo?
Oh, finally.
Andrew Poyant? Andrew? Okay. Now, that's all my list of papers. Is there anyone in the audience who wants to testify whose name I haven't called? I have 1 spot left. No? All right. Going. All right. Danny. No, Danny, you're up. We're going this way. Turn on the mic. Tell us what you know there.
Turn the mic on.
And like this?
There we go.
All right. Good evening, everybody. Good evening, Madam Chair and members of the committee. My name is Danny Vallejo. I'm a firefighter, a housing provider, a father, and a real estate professional here in Rhode Island. I'm here in support of House Bill 8066 because I've personally lived through the exact situation and currently living through this exact situation this bill is trying to address. At 163 Camden Avenue in Providence, I purchased a vacant 3-unit property that was ready to be rehabilitated and put back into service as housing. Shortly after, unauthorized occupants moved in. This became nearly impossible. There was disturbances, police involvement, and ongoing obstruction. From the beginning, I tried to handle this the right way. I led with patience, compassion, and faith. I helped with housing resources, basic needs, and tried to guide both individuals towards a better situation. I didn't treat them as a problem, I treated them as people. But despite months of effort, the situation only escalated, and the financial impact has been significant. Over the past 7 months, I've carried roughly approximately $4,500 per month in holding costs, including mortgage, taxes, and insurance, over $25,000 to $35,000 total in carrying costs alone, several thousands of dollars in legal fees and eviction-related expenses, lost opportunities from 3 separate buyers who were ready to invest and bring these units back online. In total, the situation has cost well over $40,000 to $50,000, and that does not include the cost to rehabilitate the property once it's finally accessible. Today, 7 months later, that property is still tied up. It cannot be renovated. It cannot house families. It produces nothing for the community. That's the reality we're dealing with. This isn't about a lack of compassion. It's about a lack of structure and accountability. Because we're called to care for others, but also to be good stewards of what we've been entrusted with. And right now, the system fails both. It fails the individuals who need real pathways to stable housing, and it fails people trying to provide that housing. House Bill 8066 creates clarity, it creates a defined process, and it restores balance where there currently is none. This is about getting housing back online, protecting communities, and ensuring that the right thing doesn't lead to being stuck with no options. I respectfully ask for your support. God bless you, and thank you for your time.
Danny, I just wanted to ask you, did this person who's staying in your property illegally, as you're submitting, did you ever have was there ever a rental agreement between him and that he or she and that property? Yeah.
They happen to be aunt and a niece, that they have a second floor, first floor. And then the best part, this is the best part. The first.
Oh yeah, turn your mic on.
This is the best part. So the aunt and a niece that don't get along.
And one's upstairs and one's downstairs.
One was upstairs. I came to the property and I'm like, whoa, what the?
How many units in this property?
3 units in an R4, in
Okay.
an R4 zone. And then the niece came downstairs, and the best part about this is that she rents out the rooms. So she rents out the front in a room. And during this whole time, I'm laughing. I go in, I'm like, hey, Sabrina, what's up? I'm like, got some people there. They paying you rent? She goes, oh, they didn't pay this month. I go, huh? No, kind of sucks, huh? So, but I've led with compassion. I try being helpful.
Yeah.
You know, I try to be in there. Hey, the person on the second floor, I've gotten her in contact with people at Woonsocket Housing Authority, Pawtucket Housing Authority.
Is this the aunt?
There's the aunt, yeah.
Okay.
And then the whole time, she's complaining about the first floor. The first floor's complaining about the second floor. They call the police. The other one got thrown in jail for like a day. They got their car moved out. And these are properties that we search out to rehab. And then we actually got a lot off the side to sell to an investor that actually has a foundation in place now. So there's housing opportunities.
How long have they been in there?
They've been in there. They showed up. We closed end of August. It was September 13th. I'll never forget
So
it.
they showed up after you bought it?
So we
How'd
bought
they
the
get in?
We bought the house vacant, changed the locks. Okay, this is the best part. We bought the house vacant, did a walkthrough. When I first did a walkthrough through the home, it was full of crap everywhere. Excuse my language.
Wow.
All over the place. So when I did a walkthrough and there was nothing there, I'm like, okay. We closed on the property vacant. I went through again vacant. The next time I go to show, I have investors that are looking to get in there. All of a sudden, the second floor is locked. I hear a dog, I hear people, and then she has her pro bono or free attorney on the phone saying that, oh no, this is mine, you evicted me. I'm like, I just bought this house. They had been there before, apparently. It's family of the prior owner.
Oh.
Yeah.
So that's the relationship to the property.
So they knew, they must have got, the worst part is when we went to purchase the property, we actually gave them money for the prior owner to help them move. So we gave them extra, like, okay, listen, if you guys are moving, you guys are going to be vacant, here is $15,000 for cash for keys. And so, okay, yeah, everything's all set. We waited. We had to wait for closing because, hey, we're waiting to get everything out because they left.
Wow.
Yeah, and it's wild because I have to go through it. I didn't start the eviction process because I was like, well, I'm going to help them. They seem like something. What really got me is I have a four-month-old son. He was born November 4th.
Mm-hmm.
When I got there, the first floor lady, she gets in front of me because I'm like, who are you? Because they're walking in as I walk in. I'm like, hey, where are you going? They push me, and she got a belly. She's like, I'm like, whoa. She's like, you pushed me. I didn't touch you. She goes, I'm pregnant. And I'm like, oh, this is going to be terrible. But I have a soft heart for that.
Yes.
Let's fast forward 3 months later. Hey, Sabrina, man, hey, how you doing? You excited for the baby coming up pretty soon? He goes, I lied to you. I'm not pregnant. The whole time for me to show the property, I'd have to buy cigarettes and vodka for them.
Oh, boy.
The other one got me because she had a German Shepherd. I got a Roddy, so we got like similar dogs. So I buy her vet meds and food for the dog.
Do you have a court date for all this? Do you have a court date?
It's in the process now.
When are you going to court?
It's in the process now. My attorney has it.
Oh.
So, but the thing is, the worst part, needs arrive for Thanksgiving, bought Thanksgiving pies. Now, the worst part, the last time I saw them is when the second floor tenant gave me a Christmas present for the baby. It's an artsy thing, a little cap. I was like, thanks, Sherry, that's cool, all right. Hey, can you go pay my storage fees? It's $400, $800. I can't do this anymore.
No.
It's taking time away from my newborn son, my first child.
No, you can't.
And so I stopped. We started everything the 31st of December. And then all of a sudden, what happens? Lawsuit, violations on the house, the lead law stuff, right?
Yep.
You can't evict me now. This all happened.
Oh,
and
my
why?
God.
Oh, there's no windows here. Oh, you got to do this. This is all happening today, right now.
So you're stuck.
I'm stuck.
We're stuck. You are. Oh,
right
boy.
now, we're probably stuck till June at least.
Oh.
And this is a great property right by PC.
Yeah.
Like, the people are building. There's people that want to be in there. It's a good setup. It's a great house.
Yeah.
If anybody wants to buy it with tenants inside, just let me know.
Well, good luck with that sale.
Well, with your help for our rights,
Yeah.
we'll be in a good situation.
Okay.
Appreciate it.
Thank you.
Welcome.
Good evening. My name is Andrew Poyant. I'm here in favor of 8108, the 4% cap on rent increases. I live in Providence, and if we continue to do nothing, we'll continue to see rent increases and more people living on the streets. Just last year, Providence was ranked the least affordable city in the country based on the average income compared to the average rent. That means it's harder for what people are making to what we have to pay. I've helped move 2 friends in the past 7 months whose rent increased at $700 and $500. One of them no longer could afford to live on his own, and him and his daughter had to move in with a friend because rent is too high to be able to afford anything on his own. It's gone out of control. That's why there's more people living on the street. We have people freezing to death, and this is from the current state that we live in. With just having the private side build, we can't build our way out of this when the private sector of building wants to charge more for rent. So the only way that we can do it is by capping rent increases and building more. We need to stop selling our public property and start building public housing. It can't be done just on the private side. And a lot of the concerns that were raised before about taxes or insurance, that's included in this bill, so there really shouldn't be an issue with passing it. And as far as what was said about Rhode Island Energy, yeah, Rhode Island Energy is a private monopoly. We should make it a public utility too. Thank you, and please support 8108. Thanks.
Is that it? Nobody else wants to testify, right? Well, thanks everybody for coming, and do I hear a motion to adjourn?
Yes. Second.
All in favor? Aye. Have a great evening.